It is May 2nd of 2026, and this is the Court Gallery. Is it a high-tech spy camera or a cheap plastic toy? Today we start in Thurston County with a bitter neighborhood war over surveillance and trespassing that explodes in court. Then, a father goes head-to-head with Judge Hesselink, trying to block Child Protective Services from seeing his children, while the mother makes a desperate demand to prove her innocence. We're back in Woodhaven today, where we'll witness an update to a case that leaves Judge McNally furious and walking off the bench. And finally, a man's freedom hangs in the balance with Judge Simpson after a GPS tether incident, but one crucial phone call possibly has saved him more jail time. It's an extra long weekend review, ladies and gentlemen, and it all starts right now.
Cause number 26-117, David Musgrave versus Adam Rainey. We got Mr. Musgrave here in court, Mr. Rainey on Zoom. Good morning to you both. Come on up, Mr. Musgrave. All right, I'm just closing out the exhibits from that prior case. So I know folks have been here before. Same parties have been here with positions switched. And a lot of the allegations here are sort of grounded in similar allegations. So I think we're all familiar enough with the allegations here and the responses. So rather than go over an overview here, I think what I'm going to do is give each side sort of just essentially a bit of a time limit to kind of summarize your allegations or the response. And then I'll make a decision here rather than kind of go piece by piece. I know Mr. Musgrave, you've outlined a couple of different buckets of allegations here, and so rather than me kind of go through those point by point, I'll give you some time to talk and can let me know which ones you'd like to focus on.
Sure.
All right. So it's 10:40. I think what we'll do is we'll give each side 5 minutes. And if I have some follow-up questions, we can have this be a little bit more dynamic. But again, I don't have any specific questions. I think it makes a little more sense to have folks just provide some testimony. So, Mr. Musgrave, can you please raise your right hand? Do you swear or affirm the testimony you're about to provide is the truth and the whole truth? All right, go ahead.
Okay. I'm not sure.
And you also don't have to take up the full, if you want to just say, I rest on what I've filed, that's okay.
Well, you probably read through all of this.
I have read, it looks like everything through April 20, so last Thursday. Okay. I know looks like exhibits were uploaded, and so I've read everything through that.
And a lot of these are from the previous one. So, okay. So my issues, I think I stated the problems. What I'm requesting is that, the main thing is that the cameras are that they're aimed at our backyard are removed, that the recordings of our private conversations are stopped and deleted, and that Adam and his family are served notice of trespass from our property. I also wanted to address the photo of the camera in the window. There was a heat signature there. I don't know how an empty box would have that. And and that being a protection order violation of the photo. I don't know if you saw Adams reported it to the police that was a violation of the protection order. I understood we were talking video cameras recording, which have all been taken care of, not a photo of evidence. which is what I considered that. If I had thought that that was part of the order, well, I'm not stupid, I wouldn't have done that. But I didn't consider a photo the same as the video recordings. And as you can see also in this, I have addressed those cameras. They are now moved, covered, so there are no video cameras in my backyard that are recording anything of Adam's house.
So I do actually have a question, since it sounds like you raised it. So you have alleged there are cameras aimed at your backyard, and I know that Mr. Rainey there has essentially responded that the camera referenced you took a picture of one of the windows at Mr. Rainey's home. And
it was an empty box.
And yeah, saying that was I think a Funko box. Were there other cameras?
I saw 3 different heat signatures, and I didn't photograph the other ones because they were on the first floor. But that one, they would not have been able to see what I was doing the week before in my backyard from those other cameras, but they would have been able to see it from a camera on the second floor, which was why I pointed that one out in particular. Yeah, anyway.
All right. And if you'd like to, I mean, you summarized everything rather well. I think maybe, if you'd like to just kind of rest on your summary of everything, I can turn it over to Mr. Rainey to talk about his response. And if I have follow-up questions too, then maybe I can start asking questions that way.
Okay. Yeah. But yeah. Like I said, if you read through it, I'm fairly comfortable with what I.
All right, I did read through that. So, okay, Mr. Rainey, what we'll do is we'll put you under oath. So if you could please raise your hand. Do you swear or affirm the testimony you're about to provide in this matter is the truth and the whole truth?
Yes, Your Honor.
All right. And yes, Mr. Rainey, for your benefit, I did review, looks like you filed a 6-page response on April 23rd, and I did read that. And so I did see the response with respect to that alleged camera maybe being a Funko box. I'm curious if you want to talk a little bit more about the Ring camera. I mean, I'll sort of be upfront. One reason why I granted the hearing was I know that the order in which Mr. Rainey is the protected party was grounded on privacy in the backyard. And so allegations that Mr. Musgrave made about similar violations of his privacy on filming in his backyard and into windows into his home, and then the private conversations being recorded, that more than anything else really formed the basis of my granting the hearing. Mr. Rainey, you've sort of addressed each of those directly in your responses. So those are the things that I was also concerned about, that I really set the hearing to address. And so I know that you're saying the camera, the alleged camera facing his backyard is that Funko box, and that you've provided as well some exhibits showing that the Ring camera on the side of your home that I think Mr. Musgrave was saying films into his window, and that may have been the camera that picked up the conversation that was brought up in the prior hearing when you were the petitioner, that those have been moved, or that they're no longer being used, or that the audio has been turned off, things like that. If you want to speak to those issues too.
Yeah, correctly. I'm sorry.
No, go ahead. Those were the things. Any cameras facing his backyard, cameras facing in his windows, and anything that picked up audio in an area where someone has a reasonable expectation of privacy. You've addressed those in your exhibits. Those were also top of mind for me. So if you want to direct your comments there, that's.
Yeah, certainly. Yeah, the box that's my daughter's window. It's just the empty toy box. We don't have any cameras in our backyard at all. And as far as the Ring camera, Mr. Musgrave at our last hearing said that it was offline already because he noticed the lights. So it's been off since then. And non-functional. As a courtesy, we understand his concern, and we turned it off. It was off that day. As far as seeing his backyard, we put a fence up so he doesn't have to see in our backyard any longer. So we don't have to see him. And we knew the fence, we put it up because he said he was going to do maintenance at our last hearing. So we just preemptively put the fence up in case he wanted to take the fence down, since we depend on it for our pets. I mean, there's no contact from us from his side. I mean, he has 30 cameras facing our house. Not one time has he reported anyone trespassing. So all these allegations are just untrue.
All right, so I think what I'm going to do is run through, my notes on the different claims here, and kind of let folks hear where I'm at. So number one, again, primary reason that I found grounds to set the hearing is allegations of cameras on Mr. Rainey's property facing into Mr. Musgrave's backyard, that those need to be removed. I'm hearing that there's two ways that Mr. Musgrave is substantiating those claims. Number one is viewing what was believed to be a camera that having reviewed the photo myself, not just the one blown up by Mr. Rainey, but the photo that was included in Mr. Musgrave's petition. I agree, at least to me, if you really look at it, and I have Funko boxes myself at home, and it does appear to be a Funko box. Now, Mr. Musgrave is saying that the cameras he has show heat signatures around that area, as well as that Mr. Rainey or his family know about where he may have been at certain times, and sort of that being circumstantial evidence that he's being recorded. Frankly, I don't know if that meets the preponderance of the evidence standard, that it's more likely than not that forms the basis of me being able to conclude that Mr. Rainey has cameras pointed at your backyard. So at this point, I don't think that there's anything in the exhibits or in the evidence that I can look to say, all right, there are cameras that by court order Mr. Rainey needs to remove. The issue that I was concerned about when the petition was filed was that camera on the side of the house, because I do recall from the first hearing that there was a camera on Mr. Rainey's side of his house that did pick up that private conversation from Mr. Rainey. I know, Mr. Musgrave, you've also inquired in the exhibits, kind of what do we do with that? And I think that was addressed at that prior hearing. The remedy by law in that case is the content of what is recorded without consent is not admissible as evidence against someone in a civil hearing, and it was excluded in that last hearing. I didn't consider that, and
it's excluded from evidence.
So you had asked in this petition, you had asked what was the remedy of that of your conversation being recorded, right, without your consent. And what I was saying is, well, the remedy occurred at that last hearing, which is under the statute that says you're not allowed to record someone without their consent. It says the consequence of that is if that evidence is attempted to be used against the person who was recorded, then that evidence is suppressed and not used. And so at that last hearing, I did not consider that as evidence against you.
In that particular
yes. And so
is it still a crime?
Well, and that's where, you're welcome to call police if you think a crime is being committed. I'm not going to make any kind of conclusion about something being a crime or not being a crime. And it sounds like Mr. Rainey in response has provided evidence that camera is no longer
But it could be turned right back on.
Sure. But in order for the court to issue some kind of order in an anti-harassment protection order, there needs to be a knowing and willful course of conduct that's persisting. And from my view of the evidence is that you've discovered that a camera on Mr. Rainey's property had picked up a conversation as part of that prior hearing. We addressed it, and it sounds like at this point that camera was then turned off and not recording anymore. And so you're saying, well, what if he turns it back on? The court's going to need evidence of an ongoing pattern of behavior, of you being recorded, your conversations being recorded, in order for the court to have grounds to take any action against.
But even if that camera is turned on, it doesn't have to necessarily record me to be looking into.
Right. Well, and it sounds like though that camera's off.
For now, that's why I'd asked that it be moved someplace where it can't be looking directly into our house.
Yeah, and that's so. I'm not going to sort of prospectively order cameras that aren't currently being alleged to have violated someone's privacy.
I had to move mine.
Right, because those cameras were on, right, and they were pointed at.
But they were the view of his property was blocked by the camera. Those cameras have the one that they were concerned about has the ability to block that part of its view. Right.
Well, in my understanding, Mr. Rainey, is that the camera on the side of the house, is that was that moved? I can't remember. Now I don't recall from your.
Camera on the side of the home.
Go ahead, Mr. Rainey.
The camera on the side of the home is disabled. It's deleted, and the battery is removed. It's non-functional.
Yeah. Yeah. All right. And so, and the other thing with that one, with that camera in particular, is, my concern there was primarily around the audio recording, and because when it comes to where people can put their Ring cameras to capture video versus audio, it is a little bit different because that's why people have Ring cameras, right? They film the sidewalk, they film someone's front door, they film the driveway. You do not have a reasonable expectation of privacy in places where you're already sort of out in public. If being familiar with these properties, the camera is filmed, or the camera was pointed at the end over the side door entrance to Mr. Rainey's home that did capture a portion of Mr. Musgrave's home, but this is also an unfenced side yard that
it is fenced.
That pictures.
It's completely fenced. It had a gate. It had a fenced gate as well. In fact, that's one of the things I recently included was so you could see that there was a gate and there was a fence that was there. But
the camera at issue, right, is I'm looking at the picture of the two homes now, and the camera at issue is over the side entrance to Mr. Rainey's home that is exposed to the front yard and the street. And is that right?
No, the side door is exposed to the street. It used to be the garage. They added the door off the side of the garage. Their entrance is like 30 feet away around the corner, the entrance to the front of the house. That side door is not used for public entrance. Okay,
right. But the side door, this is the camera that you're concerned had picked up the audio from the first case.
And looks into our house.
Right. So I'm looking at, now I'm going back to, I think you put the screenshot from the incident where your audio was picked up.
Right.
So I'm looking at the camera, and unless things have changed, what I can see is you talking to your friend. I can see Nova Middle School. I can see the street. I can see the sidewalk. This area is not.
Okay, it's hard to see, but right there in the photo is one of the fence posts.
Right, but but this is what the view looks like. Isn't that right? The view in the camera.
Right, it's looking over the top of the fence.
Right. So the reason I'm bringing this up is, this is an area where a Ring camera can go. The issue isn't for this camera. The issue was picking up audio without consent, right? Because it is yes, it is part of your house is on the camera.
And it was in a fenced in area. There was a
Right, but I mean more the fence here. It's not exclude. When we're talking about a fence in this context, we're talking about, is this a fence that if you're on the other side of it, it's indicating you have a reasonable expectation of privacy. And here, the area being filmed by the Ring camera is exposed all the way. Again, I'm looking at Nova Middle School. I mean, so it's across the street. You can see into this area. So there's, you being in this area doesn't necessarily give rise to a reasonable expectation of privacy. Now, again, your audio being recorded without your consent is a different issue. And that's the issue that we took up in that first case. And it sounds like Mr. Rainey has disabled that feature as part of this camera. The camera itself, though, as a Ring camera is traditionally used, this is not a place that I think is violating anyone's reasonable expectation of privacy. Because again, it is in an area that is fully exposed to the sidewalk, the street over.
It's like 40 feet from the street.
Yeah, but I find that
80 feet from that school.
But I think that the position of the camera, I think, is not something I'm concerned with as far as a violation of a reasonable expectation of privacy. It was the audio recording for that camera in particular. Going down the line, you've also brought up essentially wanting Mr. Rainey and his family to be served notice of trespassing. And it's the grounds there. So first of all, there's nothing about the anti-harassment process that has a formal relationship with a trespass notice. You as a private property owner are free, and sounds like you have put up no trespassing signs on your property. The way the unlawful harassment process would interact with that is if there is trespassing that then also meets the definitions that we've gone over before, trespassing happening as a ongoing course of conduct for the purpose of harassing that reasonably causes substantial emotional distress. You've alleged that Mr. Rainey's daughters, again, have gone onto your property to retrieve Amazon boxes, and that there's been occasional times when they've walked across your
daughter and son, after the no trespassing sign and fence were up, snuck across the front yard, rather than walk around, come up the driveway, which is what I understand is the proper path to the front door when there's no trespassing signs.
And so there's a difference. There's three types of trespassing here. So there's criminal trespassing, right, where you would, and you have called the police saying, someone is coming onto my property without my permission. And so, if you feel that is happening and someone is criminally trespassing against you because they have notice not to come onto your property and they're doing it anyway, you call the police. That's a criminal matter. There's civil trespassing, where you have to show that this is causing me some kind of damage. And, there you have to actually show, there's this level of damage. For purposes of harassment, again, there needs to be trespassing to a point where it's a knowing and willful course of conduct happening for the purpose of harassing a specific person, and that causes substantial emotional distress.
The incidents I have brought up with the contractors.
Well, and again, we can't just say trespassing for a bunch of different people. We have to stay focused on specific allegations. So you've alleged that Mr. Rainey's daughters are trespassing as grounds for anti-harassment.
Okay.
Yeah.
Well, that's just one. That's like the last incident, but there were
right. But you
at least a half a dozen incidents before that where I had to keep telling people to get off of my property.
The daughters in particular?
Huh?
The daughters in particular?
No.
Well, that's why, again,
the Rainey's contractors who kept using my lawn.
So that's the contractors. That's a different issue too. So we'll get to the contractors.
But they were telling them to use my lawn.
Okay, but we're going to stay on the daughters for a second. Okay, because you have to allege trespassing against someone, right? And so you can't say I'm being trespassed against by these people and the contractors.
I had also pointed out the roofing people. That was one of the
Right, that's right.
specific incidents.
So staying on the daughters though, I don't think that there's trespassing by Mr. Rainey's daughters in a way that satisfies the unlawful harassment statute. I don't think there's a pattern of behavior of them coming onto your lawn.
I thought that repeated trespassing,
even if it happens more than once, again, that there needs to be an ongoing course of conduct that rises to the level of causing.
Well, that's why I was mentioning all the contractors that led up to me having to put the fence up and the signs up
missing. Okay, hang on. The point that you're missing is you need to allege trespassing against specific individuals.
Okay.
Right. And so you're saying you were trespassed because Mr. Rainey's contractors and roofers, a couple years ago used the part of your property for their work, and then also
will have been ongoing over the last 2.5
so you need to there needs to be more of a focused allegation, because I can't just say the world around Mr. Rainey's property that is trespassing against there needs to be specific instances that you're tying these allegations to against specific people. Right. And so you've alleged, number one, Mr. Rainey's daughters trespassing against
and the roofers and the paver installers.
All right. So I'm not finding that any of this rises to a level of an ongoing course of conduct, a knowing and willful course of conduct, that there's trespassing happening. Now, if you've alleged many times that you think there is property damage on your property from Mr. Rainey's contractors and the roofers, right? And I think you've also acknowledged that is property damage, and that's if you want to bring a small claims action or any other kind of lawsuit against Mr. Rainey for property damage, that's different than unlawful harassment,
which is planned. Yeah,
right. So that's different than unlawful harassment. So
I still don't understand. Like I said, the pavers, the roofers. There was the one photograph that I included that showed all of the different projects that are on that side of the house that he has had contractors stage those projects on my lawn. And I've had to go out there and tell those contractors to move their stuff off of the lawn.
I know, and to the extent that you have alleged that those contractors are coming onto your lawn to stage the work, I'm finding that that's not a knowing and willful course of conduct for the purpose of harassing you that would reasonably cause substantial emotional distress. If he
knew that I told them to stop doing that, and he would still send them over there.
Right. No, I understand. And again, to the extent you have a property damage claim that you would like to litigate, that needs to just be litigated. That's not for unlawful harassment.
I understand that's completely different. I just feel like there has been a pattern of trespassing.
And I understand. So Mr. Rainey, maybe it would be helpful too if you'd like to maybe provide some concluding remarks on when you've got contractors doing home improvement projects, where you're telling them to go, if you're having them avoid coming on to
we actually do. Anyone that comes to our home to do any kind of work at all, we tell them to avoid that side of the yard because Mr. Musgrave will come out and yell at them and say things to them. So we tell them just avoid that area altogether, and they stay on the other side. I mean, I don't know where he's coming up with that. They're walking there constantly. We haven't had any work done in years, and honestly, it's kind of ridiculous. And the only other thing I would like to address is Mr. Musgrave has cameras pointed directly at our driveway 24/7. He claims in his filings, and then he's posting the videos up on YouTube. And I don't understand how that is different than his claim that we're recording him from a Ring camera.
Right. Okay. So I want to stay on the contractors piece of it. So
the roofers were there this year, not years ago.
Right. Well, if I
The thing,
understand
the thing about roofing is they were very careful. There's a dumpster in the front of the house they were scraping into, but there's wind, things accidentally blow over. It was like one piece that fell on our side of the yard that he threw over. So I mean, this allegation that people are throwing stuff on his yard is unfounded and ridiculous, to be honest.
Yeah, so we're gonna put that allegation to rest. So, Mr. Musgrave, I understand you're frustrated. Sounds like in your mind that there's ongoing trespassing on your property from contractors working for Mr. Rainey.
Why the fence and the signs are there,
right?
And the cameras.
Right, I understand. For purposes of getting an unlawful harassment order, I'm not finding that constitutes a knowing and willful course of conduct that would reasonably cause substantial emotional distress, or that's engaging for the purpose of harassing. I'd find that that's just not in evidence at this point. Now, again, if you feel your property has been damaged or you think people are criminally trespassing, you have rights to call the police or to file a lawsuit. But at this point, I'm not finding there any grounds for unlawful harassment for what's been alleged there. On the recording piece of it, Mr. Rainey, to address your concern there, it was cameras pointed. Again, this is where we get into where is there a reasonable expectation of privacy, and it can get a gray area. There is a big difference between front yards, driveways, things like that are exposed to the world, and areas that are more private. The issue before was, again, this is why it's a gray area. When you're on the side of the house that is between the two of your homes, that is exposed to the sidewalk. But when it's a private conversation between two people kind of off on the side of the house on their own property, that's a little bit different than somebody out front in the driveway near a sidewalk. So for purposes of what kind of audio gets recorded, I think those are different situations. But again, I think for purposes of where your Ring camera is, as far as it not recording audio on the side of the house that reaches all the way over to Mr. Musgrave's property, that sounds like it's already been addressed, and you're not recording audio over that camera. But to the extent that Mr. Musgrave has cameras pointed at driveways and in the front yard and the sidewalk, that's clearly a public area where there's less of a reasonable expectation of privacy there. There was allegations about landscape trespassing, landscaping being over the property line. Again, there's a lot in the allegations around conflicts in property lines. Again, that's not something we address here at the anti-harassment calendar. Those disputes are litigated in Superior Court. So if if folks want to petition for a boundary line adjustment, do a quiet title action, to really verify where the property line is, again, that's a matter for Superior Court. We don't resolve that here.
Both his contractor and I know that you can find the steel pins in the plat.
But that's right. That's contractor's opinions on a property line is not, that's one thing. But if there's a legal dispute over property lines, that needs to be resolved.
I used a metal detector to find the steel pin at the front. Right. Which is one of those things I read is the way to find the property line.
So on balance here, again, the two things that I was primarily concerned with in the petition were if the fenced backyard area of Mr. Musgrave's property was being recorded by cameras on Mr. Rainey's property. That was my first concern. I think that has been addressed, and I'm not finding that there's evidence of that occurring by a preponderance of the evidence.
Your Honor.
Yep.
Am I able then to photograph the other cameras that I believe are there?
Hang on. We'll get back to that. The second is the camera on the side. The camera over the side entrance to Mr. Rainey's home, where there was originally the concern about private recording of private conversations without consent. Mr. Rainey indicated that camera no longer has that audio feature. There was evidence of that occurring one time. There's not evidence of a pattern of behavior, a course of conduct where Mr. Musgrave's private conversations are being recorded. And so given that, and given the testimony from Mr. Rainey that audio feature has been turned off, I'm not finding grounds for an anti-harassment order on that front as well. We've addressed the trespassing and the property damage and the property line disputes as well as not relevant for anti-harassment orders. Mr. Musgrave has asked about, is he able to take pictures of Mr. Rainey's property as evidence that his privacy is being violated? There's an order in place, and I know there's a question about the current order and the restraint provisions in the current order where Mr. Rainey is the protected party and Mr. Musgrave is the respondent. There are 3 restraint provisions, and they say, number 1, there's no cameras recording petitioner's backyard or pointed at petitioner's windows. Number 2, no cameras on petitioner's side, so Mr. Rainey's side of the fence. Number 3, no pictures placed by Mr. Musgrave on Mr. Rainey's side of the boundary fence. So this seems to be a question about cameras recording Mr. Rainey's backyard or pointed at Mr. Rainey's window. Mr. Musgrave, if you feel that you're seeing evidence that your privacy is being violated by cameras pointed at your window, I'm not going to say you can't take that picture. The language of the anti-harassment order in place prohibits the recording of Mr. Rainey's backyard or cameras pointed at Mr. Rainey's windows. And I think in context too, it was recording cameras is what we were talking about.
Right. Yeah.
But at the same time, you got to be careful though, because there is this order here in place. And if you're doing things like taking pictures of the windows at Mr. Rainey's home, and it turns out to be a toy box or something like that, that's what you want to be careful about that. You really, you're going to want to have a little more solid evidence that your backyard is being recorded before taking pictures and doing things like that, and coming back to court.
Okay.
So I want to caution you.
I had picked up a heat source there. It looked like there was a camera lens. I realize now that's probably the part of the box.
Okay, but Mr. Musgrave, also be careful because you're talking about you've got a device picking up heat sources, right, at Mr. Rainey's home.
That was a few weeks ago.
Right, and so I remind you that there's this order in place saying you're not allowed to be recording or having cameras pointed at Mr. Rainey's windows or backyards. And so to the extent you have devices that are picking up heat signatures, right? I mean, you got to be careful about that.
It was my phone.
Okay.
All right. Yeah, it was just an app on the phone that does that. And so I checked one time to see, and I think I put in one thing that I saw 2 or 3 heat sources there.
Well, okay.
And there's other ways to find cameras with their infrared or their blue light, night vision stuff. That's why I'm asking is, if there are still cameras over there, and I want to prove there are still cameras pointing at my backyard, am I allowed to do that?
Yes, you are, but you can't. I'm not going to give you legal advice, right? But you've heard what the petition against you says,
right?
If you have a reasonable this whole thing started with allegations of infringement on a reasonable expectation of privacy, right? And so I would also caution you on, if your need to collect evidence of an invasion of your privacy raises to the level of you needing to get night vision goggles and heat sourcing. Before, right, there were cameras pointed into Mr. Rainey's backyard that were causing emotional distress on the part of Mr. Rainey and his family, right? Part of the anti-harassment order statute, as I went in before, is the behavior alleged needs to cause someone substantial emotional distress, right? And so if you're needing to seek out that type of evidence against you, it also, there's an issue there. Are you feeling a substantial emotional distress because of something happening to you, versus you going out and trying to find something that's going to?
I'm stressed. I'm very stressed. You could talk to my therapist about
I can
that.
tell. So again, I'm not going to give you legal advice, and I'm not going to say what is or is not a violation of the order. What I'm going to say is, if you want more specific questions answered about that, you can always talk to an attorney. And keep in mind that the order in place right now prohibits the recording of Mr. Rainey's backyard or recording, having cameras pointed at Mr. Rainey's windows, given that he has a reasonable expectation of privacy.
And the cameras recording to me meant video. I didn't consider a photo recording. I understand. I have looked up to see whether a photo is considered a recording, and there is references to that in Washington law because it's a record. Mm-hmm. The photo is a record. It's yeah.
Okay.
But that's not, from a layman's term, what I thought we were talking about.
And there's not an allegation against you as part of this hearing. So
right, but there is an allegation against me based on that protection order
that's not being heard today. And again, I don't want to wade too far into those waters because that's not before the court right now.
I'm just trying to be clear about whether
and that's why I'm having this discussion, is because I do want to try to resolve confusion here so that folks aren't coming back to court. And unfortunately, the scenario you're bringing up, I think, has a lot of gray areas. So that's why all I'm going to do is caution you and advise you maybe talk to an attorney before you do things like that. Because
that's what I was asking. I
can't give you legal advice on complying with the order. All I can do is read you the order and read you, what the unlawful harassment statute is. Mr. Rainey, do you have any questions? I know you've been here during all this.
No, I have no questions. I just want Mr. Musgrave to understand that we do not find him interesting enough to record him, to watch him. We don't have any feeling for him. So all this nonsense about whether to take pictures of my backyard are kind of silly because we don't care to do that and we have no cameras. So, I mean, that's all I have to say about that matter.
All right. Okay. Well, so that'll be it for today's hearing. So I'm not going to sign an order. Mr. Musgrave, if you have questions about what kind of conduct may or may not violate the order, I strongly suggest you talk to a lawyer. Particularly if you get into this kind of gray area of, using your phone to capture heat signatures and things like that. I'm not going to tell you if that's a violation or not, but I do suggest you talk to a lawyer before doing that.
Who does tell me? I'm confused.
A lawyer. You're going to have to talk to a lawyer who can give you legal advice.
My wife's an attorney, and I do talk to her, and she says, hang on.
Okay.
But she's like kind of confused by the same bit of the recordings and photo and whether that's what you intended by that
the
order.
intent, this is the last thing I'll say, and I'll let folks go. The intent is to not infringe upon the Rainey's reasonable expectation of privacy, right? So that's the whole reason of this whole order and of the statute. Is part of the reason here is there an unreasonable infringement on a petitioner's reasonable expectation of privacy? So maybe it would be helpful to go back and not focus so much on the exact definition of what is a recording versus what is a photo. Think about what is a reasonable expectation of privacy, right? Because that is what the statute is intended to protect. And so is somebody using their cell phone with an app that reads heat signatures or night vision, but it's not necessarily recording? Does that violate this order? Again, I talk to an attorney. I'm not going to say, and I'm not going to tell you one way or another. I'm not going to give legal advice, but I do suggest that you think about what is the purpose of the order here, which is to protect a reasonable expectation of privacy, and whether or not observing that kind of data would make someone feel like their privacy is being infringed or not. So think about it that way. Again, I'm not going to provide any answers here. Think about it that way. I'm not going to sign an order today.
And what about his camera looking in our house? I don't have a.
So we've addressed
I
that.
understand he's turned it off, but it's not that hard to turn it back on.
Well, again, we've addressed that already. So I'm not signing an order today. You're all free to go. Again, if you have questions about the order that's in place.
I kind of felt like, yeah, that's okay. It's there as long as he doesn't turn it back on. But if he turned it back on, then he would be violating a protection order. That's what I was hoping. Because it's just that easy. It's like me pointing a camera at his backyard again.
Right, but
none are pointed there right now.
But it's not on right now, right? So what I would need is evidence of ongoing recording in a way that violates Mr. Rainey's reasonable expectation of privacy. The only evidence I had of that was the private conversation that had been recorded before. And that was one incident. And there hadn't been more. It sounds like it's been turned off. So there's not a basis for me to issue an order on that basis right now.
Okay. Yeah. Okay. Well, yeah.
All right. Thank you, Mr. Rainey. Thank you, Mr. Musgrave. That will be all for today.
Thank you, Your Honor.
Next case on the court docket is that of the Hesselmeyer and Boffman children. That's file J25-326-NA. If I can have the appearances of counsel, please, Mr. Sonnenfeld.
Thank you, Alex Johnson, I'm for the Department of Health and Human Services.
Larry Brown on behalf of Jenny Scott.
Mr. Delaney.
David Delaney for Father Skip Bowman. I've not had contact with him. He's not here in court, and I don't think I do not see him on the screen.
All right, my staff is letting me know he's not here, so let me make sure I got everybody. Mr. Brown, you have Jenny Scott, is that correct?
Yes, Your Honor.
All right, thank you. I do see Mr. Hesselmeyer is present. Ms. Scott is present as well. Mr. Dowling, are you present with us?
I am, Your Honor, yes.
I'm not able to see you. Can you turn on your camera, please?
Trying, Judge.
Just for everybody's information, we're having a connection issue with Mr. Dowling, so we're put him in the waiting room and bring him back out, see if that helps. You had any success yet, Mr. Dowling?
Not yet, Judge. I'm still trying.
Let's see.
We have to just go with just
Hold on.
I typically use a hammer.
What you feel like doing? Okay. Dad.
Judge, I'm just not seeing where it allows me to change anything. Could I just
Well, hold on here.
just appear verbally?
Yeah, we'll do that if we can. It's always nice to be able to see each other, but if we can't do it, again, there's typically what looks like a little video camera button, but if not, we'll go ahead. If you find it later, go ahead and push it, and we'll greet each other then. So,
Judge,
all right,
it says it's disabled by the host. It says this camera is disabled by the host.
well, we can try to fix that.
Okay.
Thank you for letting me know.
Yeah.
You good now?
Yeah, I did that so that it would let me hit F to start video, but.
All right, if you're able to find a video button, Mr. Dowling, go ahead and try it, but we'll proceed otherwise.
Thank you, Judge.
All right, we are here on a pretrial hearing for mom, Jenny Scott, and a review hearing for dad, which would be Mr. Boffman, who's not present. And let me indicate the reports that I've received already. I have the MDHHS review report dated 4/27/26, case service plan between October and January of 2026, October 25 and January 26. Parent agency treatment plan for that same time period, October through January. Case service plan, from January through April of 2026, and the parent agency treatment plan from January through April of 26. Mr. Sommerfeld, is there any other documentation I should be aware of?
No, you have it all, Judge.
All right. Any objection to those documents being admitted?
No objection. No objection.
All right. Those documents will be admitted. As to the review hearing first, Mr. Boffman is not present. Where do you want to go with that, Mr. Sommerfeld?
Has he been properly served? Otherwise, I do have a witness to present some brief testimony just to supplement what the court has already received as a form.
I have a notice of hearing for today's date, April 28th at 3 p.m. In the courtroom via Zoom for that was mom for the pretrial hearing.
Judge, there is another issue we need to bring up involving Miss Casey's contact with the Hesselmeyer children with the non-respondent parent.
Yes, we'd actually like to comment on that as well.
All right, let me figure out which I need to do first, and then I'll let all the parties have their say as to that issue. Is there some reason that needs to go first before the pretrial on the mom?
No, we could do the pretrial first, Judge.
All right, let's do that. Mr. Brown, how does your client, Ms. Scott, wish to proceed as to the adjudication of plea?
Your Honor, we were not really, she doesn't want a trial, but she also is not going to plead. So I don't think really have any choice. But
that's an interesting way to proceed.
So I don't
would you like to do?
Well, I don't think I have a choice other than setting this for a trial, Your Honor.
Ms. Scott, I know that you're trying to talk, but you're on mute at the moment.
Okay, I apologize. Your Honor, I am demanding a hair follicle test. Literally. That is all I want. I want a second opinion for my psych eval from somebody I pay for out of my own pocket, not provided by the state of Michigan. And I want a hair follicle test.
What stops you from getting a hair follicle test?
Honestly, I don't know where to go and how to go about it and do it. So I want to do it to prove that all these allegations are wrong.
All right, Mr. Brown, Mr. Sommerfeld, are you familiar with a lab where hair follicle tests might be done, or would DHHS have options to that?
Well,
it would not be at DHHS cost.
What would be? I don't know what the hair follicle test would be for. Is that for testing?
Because they are trying to say that I have substance abuse and I'm an alcoholic, and I'm not. I haven't drank in years. I don't use substance. I've been clean for 5 years since I left Skip Bachman dying at 60 pounds, locked in a room.
All right.
That sounds like a trial issue to me, Judge.
It does, but I want to make sure that she has the ability to put on a defense if she wishes to put on a defense. So I'm simply asking for information. Is the department or yourself aware of a lab where she could contact and have that done?
We could try and find one, Judge. The allegations, I don't believe they're for current drug use. It's for allegations of things in the past. So I don't know really the relevance of her request.
Mr. Brown, are you, hang on, Ms. Scott, just a second. Mr. Brown, are you aware of labs that could potentially assist your client?
I am not right off the top of my head, Your Honor. I'm not that familiar with follicle tests. I did try to speak with Ms. Scott yesterday about this. That again, this petition is almost a year old.
I want to go to trial. I want to prove my allegations wrong. And so far, everybody has.
Ms. Scott, we are discussing how that was going to happen. So if you slow down just a second, you'll see that we're moving in that direction. It just takes a little bit of time, and we have to do things in order. And I apologize if it's going a little bit slow for you, but I will give you another chance to speak in just a minute. I just want to make sure I understand where Mr. Brown is going. So, Mr. Brown, I'm going to leave this in your capable hands about whether or not you contact a lab and how you present a defense for her. I'm not going to order DHHS to take any action with that. That's not their role. My inquiry was simply, is there any available local information about that you could tap into? I believe that you could, when I was in Mount Pleasant working for the tribe as a judge there were a couple of substance abuse labs and clinics there. That might be a good place to start if you don't know of any others. I don't have names for you, but it was on the internet. If you just Google DNA labs and Mount Pleasant, you probably pop right up. So I'll leave that in your hands. We will set this matter for a trial. Are you asking for a bench trial or a jury trial, Ms. Scott?
Can you please explain?
A bench trial means in front of me as the judge. A jury trial means in front of 6 jurors from the community.
Just want to talk to you, Judge. That's it.
All right, we'll set it for a bench trial.
Judge, if I could just make a couple things clear. Mr. Brown said this case is almost a year old. The original petition was, I signed it on June 18th of 2025. We have recently filed a supplemental petition that is in relationship to both parents that was filed on February 27th of 2026 this year. It requests termination of parental rights. So while it would be proper, we have to go through an adjudication for Ms. Scott because we do not have jurisdiction over her. However, I know Mr. Skip Bauman is not here today. However, since he is already under the jurisdiction of the court, we would be proceeding on a supplemental petition under MCR 3.977. It would be F. And that would be based on the new allegations in the February 27th, 2026 petition.
What new allegations?
Abuse and neglect.
Ms. Scott, you can find those allegations in the paperwork that were filed back in February. And if you talk with your attorney, I'm sure that he'd be more than happy to discuss each of those with you so that you know what you're charged with. Mr. Sommerfeld is simply pointing out that the case isn't quite as old as the comment was, and that's quite frankly not a big deal at this point. But the allegations that you need to be concerned with are in the February 2026
which is
petition.
why I want my second opinion with the second psych eval.
And you'll be able to do all of that on your own and with the assistance of Mr. Brown if he believes that that's appropriate. So we'll set a bench trial. It will be for a full day. It will be in front of me alone. That notice will come out. I'm assuming, Mr. Brown, that you're going to ask for 60 to 90 days lead time to be able to prepare for that.
I would request at least 90 days, Your Honor, if she is going to want to get some of these other tests taken.
Thank
And
you.
I think that would be appropriate because the lab work is going to take some time. You're going to need to find out where to send it and how to do all that. So we'll do that. We'll set it for a pretrial conference 1 week in advance, just to make sure we've got things covered and no last minute details. Not as big a deal with a bench trial, but I want to make sure that we've got all our ducks in a row at that point so everybody can tell me how things are going. I will not need jury instructions at that time, but I will ask the parties to exchange witness lists and exhibit lists 14 days in advance of the trial.
What was the second one after witness list?
The witness and exhibit list.
Exhibit.
Exhibits are the documents or the other evidence that's put into court. And
I got
Mr.
a
Brown,
whole book.
yeah, Mr. Brown knows all about this. He practices in front of me on a regular basis, and this is one of my normal requests. So we'll do that. Any evidentiary issues, things with the rules of evidence, will be motion at or before the last pretrial, so that we've got all that taken care of as well. Mr. Sommerfeld, is there anything else that we need to do as far as the pretrial goes?
Yes, Judge, since we have filed a termination petition, we're here for a pretrial today under MCR 3.977. It's capital D. It's called suspension of parenting time. I'm sorry, Judge, I misspoke. In the petition, the department alleges aggravating circumstances under MCL 722.638, both under number 1 and 2. It applies to Skip under 1. The allegation that he was the parent and he abused the child and it was by criminal sexual conduct. And then if that part is met, when you look at 2, it looks at the request for relief, where we would file a termination petition, and that would be for Skip. And also, if, as alleged in the petition, Ms. Scott, she had the opportunity, she knew of the abuse, she had the opportunity to prevent it, and she did not do so, there's also a request there based upon the aggravating circumstances that the department is asking the court to order that reasonable efforts not be provided based upon those aggravating circumstances.
All right. Mr. Brown, any objection to that?
Your Honor, I believe
Can I say something?
for parenting,
Ms. Scott, you have to give your attorney a chance to speak first. If you have a question or have an issue, I'll get to you in just a minute, but you have to let your attorney go first. Go ahead,
Okay,
Mr.
thank
Brown.
you.
I believe her parenting time was suspended back in September of last year. As far as continuing to provide services, I have not spoken with Ms. Scott regarding that. I would object to that, but again, it's a general objection. I have not really spoken with her, had that opportunity to have meaningful communication.
Ms. Scott, do you have something that you need to say about this issue?
Yeah, Officer Skip Buckman was military trained, and I was locked in a room at 60 pounds. I didn't have ample time, and I got proof of it.
All right, Ms. Scott, you're going to have a chance at the trial to bring out any defense that you want to bring out. So that's not what we're talking about today. The request from the department was what are called reasonable efforts in providing services while the case is pending. And so because they have alleged under the statute, because they've alleged that there was criminal sexual conduct by the dad, and they have alleged, they haven't proven it yet, but they've alleged that you failed to protect when you had the opportunity to, you'll be given an opportunity to contest that. But that allegation is, so they're asking that they not provide services to bring the kids and you back together again. And it makes sense because there's been a suspension of the parenting time. So it really isn't going to change anything that happens to you. It's just a matter of DHHS not providing services. If they can't prove their case, and if you are successful, services would be reintroduced at a later time. If they are successful, then there would no longer be a need for services in the future. So I think it would be appropriate at this time to enter an order as part of my order that DHHS not provide further reasonable effort services until such time as there's a determination at the trial. Anything else, Mr. Sommerfeld, for pretrial purposes?
No, and if the court order to be clear that that's based on the preliminary finding of, much like if we would have filed this petition first, if this was our first petition, we would have made that same request based upon the allegations under MCL 722-638, both subsections 1 and 2.
So
All right.
Your
Thank you
Honor.
very much. The court order will so note that statutory subsection.
Thank you, Judge.
All right, now we are to the issue of that Mr. Summerfield wanted to address involving the two children that are with Mr. Hesselmeyer. So I'm going to let Mr. Summerfield go first, and then Mr. Hesselmeyer, I'll give you the floor and let you tell me anything else that there is for me to know. Mr. Summerfield, go ahead.
Judge, thank you. Judge, in this case, back when we filed our original petition back in June of 2025, last year, there's been issues. We have non-respondent parents. The department is required to meet with the children at least once a month. There's been issues with that has not been happening on a consistent basis. This was brought up with the court. I believe it was in front of Judge Cooper at the referee stage because it was at the preliminary hearing. My notes indicate we're talking about August 19th of 2025 last year that this issue was brought up. We've had some success based upon the referee speaking to Mr. Hesselmeyer to make his children available. Now, Ms. Casey has told me that she has not missed. I missed
a visit with Arian last month because he was AWOL.
So,
and then this month, I did not receive communication time.
I don't know that they're going to be able to hear you unless you speak up just a little bit.
I didn't know if I was allowed to talk
Go
right
ahead.
now. Okay. So essentially, they have been allowing me to visit the kids. The issue is that the communication with me is not on a timely basis. So I got notified yesterday after hours, so not until this morning, that I could see the kids tomorrow at 6 p.m. I am not available to do that any longer. I send them a list generally at the beginning of the month when I'm able to visit. I ask them to respond as quickly as possible to let me know what date and time would work best for them. I usually don't get a response until a couple days before or the day before of when I can visit. I have a lot going on with
Give you as much
cases and then also in my personal life because they requested an after hours visit, which I'm fine with accommodating, but I need better notice. And I do. I'm asking just for 5.
I'm going to let you talk in just a minute, sir. Let her finish and then I'll let you go.
All I'm asking for is 5 days notice, 5 business days. So a week in advance so that I can make appropriate plans between my cases and then my personal life so that I can see these kiddos. I recognize that they do not want me to come see the kids. They are with their dad. They are taken care of. I'm sure that's what they're going to want to talk to you about. And I get that. I know they don't want me there and that's fine, but they're always respectful when I visit. I just need more notice.
Yep. Mr. Hesselmeyer, your thoughts?
Your Honor, it would actually accommodate both of us better if instead of having to have a 5-day notice, we just reduce the amounts of visits because it's already been detrimental the entire time to the children. They don't want to speak to her anymore. She keeps dredging up stuff. She's not a professional counselor. She's making my children relive these things over and over and over again. I honestly think once every 3 months maximum, possibly once every 5 months, because we don't really need to speak with her. We aren't the bad people who got in trouble, who did something wrong, that even need the CPS to come visit us over and over and over again, Your Honor. It's neither one of the children want to speak with them. It's not just Miss Casey. It's not just in particular her. It's they literally don't want to talk to him. He's already got a probation officer that he's speaking to. He's been doing his counseling the last few visits, and he's been doing remarkably better. We worked out a great understanding on some of the issues he was having, which he was AWOL. He left a note as you told him he was allowed to do when he needed to. He did leave a note when he left. They're now trying to use this to manipulate the situation further, as they have done in the past, by connecting his criminal trials to the parental trials somehow. And CPS managed to link themselves into both so that they could run their mouth and talk all they want at both trials, which honestly, one of them had nothing to do with them in the first place.
Probation's already
The
monitoring.
probation is already monitoring him. They're already taking care of him on that situational level. The counselor is speaking with him to take care of him emotionally and any of his concerns and traumas. We don't need them anymore. Honestly, the last time that they kept speaking to him, the only reason they did was they were hoping that they would assist us with the gym membership, which I'm not even sure if they ever did, because the last 3 or 4 things that they've held the kids that they were going to do for them, they never did. She's promised them bikes. She told them once that we would go bowling, and then there was a league there that night. Like, why would you set it up with us in advance? She went and got Aiden from Clio all the way downstate by Flint, and
Okay,
getting without making this.
Mr.
a plan,
Hesselmeyer, slow down,
right?
slow down. I
Okay.
know that you've got some grievances, but this is not the time or the place for all of those grievances. So I get it.
There's never been a time or place, sir. Every judge has told me, oh, well, it's not time to talk about this now. It's not time to talk about this now. And I never get to talk about these things. I got to make them known to you, or else
I'll agree
it'll
with
keep
you,
getting
Austin.
over.
I'll agree with that.
Thank you. I appreciate that. They don't need
Ms.
CPS in their life
Ms. Scott,
anymore.
Ms. Scott, I don't need people yapping when it's not their turn to talk. This
Sorry,
is not.
agreeing with
this
my
is not the-
ex-husband.
This is not the street corner where everybody gets to talk all at the same time. You had your chance. Mute her, please. All right,
Your
Mr.
Honor.
Hesselmeyer, I can appreciate your frustration, but there are certain rules that have to be followed, whether you like them or not, whether you think that they're good or not. I don't make all of those rules. As a judge, all I can do is say, I try to make things as easy as I can for everybody, but there are certain things that need to be done. One of those things is, while the case is pending, CPS has to put eyes on your kids because they're under the court's jurisdiction. And I have given them the ability to do that. I don't have the ability personally to come out and say, hey, are your kids still okay while the case is pending? That's what MDHHS does for the court. That's one of its roles. I get it that it has other roles as well. CPS is one of those roles. That's not exactly what's happening here. This is just making sure that the kids are okay. It's checking in, seeing what the kids are doing, making sure that no circumstances have changed, seeing if there are any other services that could be used or available, and making sure that the court knows about those things. Mr. Hesselmeyer, hang on. I'm talking. I gave you a chance. You have to let me finish with things, and then I'll let you speak again. And again, I know that you believe that the government is against you in many ways. I understand that about your worldview, and I'm not disparaging that. I'm simply saying that even with that worldview, I, as a judge, have to do certain things. And one of those things is I have to have DHHS at your home on a monthly basis, seeing that the kids are okay. That's what they're there for. That's what the court process requires me. Again, I think that you'd be angry with me if I weren't trying to make sure that your kids were okay and one of them got hurt.
Because they were in a dangerous place.
I didn't say that it was, but life happens. Bad things happen. You were gone from your previous place where you lived in Genesee County, and you went to Kalkaska, and you didn't tell us. We didn't know where you were.
In the middle of
all I'm saying is that's an example where nobody was doing anything wrong, but the court didn't know where the kids were. And that, as a dad, I would think that you would understand that if you don't know where your kids are, if you don't know where the people are that you're responsible for, that causes you to worry. So it causes me to worry because I'm in a responsible role for you and for those kids. So I have to have somebody check in on a regular basis and say, yes, they're okay. Nobody's trying to pin anything on you. Nobody's trying to pin anything on the kids. We're simply saying, are they where they're supposed to be? Dad, are you having any troubles that we can help you with, that we can give you services? Do you need anything from us while we're getting the case ready and getting everybody through the case? You have, over the last few months, been cooperative with the court. And I appreciate that about you. And in the beginning of this case, I was wondering whether you were going to do that or not. And you have. And so I'm giving you the benefit of the doubt now. And I'm simply asking that you do that to me as well. I have a responsibility to make sure that the kids are okay. It's not me saying, hey, I think Dad is doing something wrong. Go out there and investigate it. It's simply eyes on. Everything looks good. There's no services that they're asking for. There's no services that we think that we have that we can give them. Therefore, everything's good. Does that help at all?
Yeah, I understand exactly what you're saying, sir, but it's literally putting me in danger of losing my job. It's one more day that I have to go leave early from work, and on top of all the other days that I have to take off to deal with the court situations in general, with his other stuff, to deal with his counseling. I have to go and take him in person. I have to be there with him. So I'm taking off those days. The same for probation. I'll have to take off half of a day or an entire day to drive him to Gaylord and back because we couldn't get him into Kalkaska probation. So I've missed 3 hours today of $42 an hour work that I will not be able to make up. And
Mr. Hesselmeyer, I apologize for interrupting there. I'm sorry about that. I heard DHHS say that they can make themselves available after hours. So she may be able to adjust her schedule so that when you are normally home with the kids, she can stop in, but she just simply needs a longer period of time ahead of time to schedule that. So she would adjust her normal work schedule instead of 9 to 5 to be noon to 8 or whatever the time period would be required. She just needs a longer period to do this. So nobody's asking you to miss work. We're simply asking you to do a better job of scheduling it ahead of time so that she can make that after hours connection with you.
Yes, Your Honor, I understand that. What I'm saying is she gave me a 1-day notice to give her the response. I gave her the next day notice, and that's not good enough for her. I get it. I understand, but what I'm saying is that she just only offered the later services last week last month when
so going forward, that sounds like a workable deal, right?
Right, because I cannot get out of work before 3:30 ever.
All right, so
unless sometimes without leaving work early.
You need to specify
let's start right now. The next meeting. When is a good time to be available after hours? What time do you propose, Mr. Hesselmeyer? What day and date and time?
Without knowing your schedule, we don't know.
Honestly, I have to look my schedule over and figure that out because I don't know. I'm doing so much.
Can you do that? Can you do that right now? Can you do that right now so that we don't have a problem scheduling it in the future? And then at each one of the next hearings or each one of the next meetings, you can schedule the next one so that everybody knows ahead of time when it's going to be and where it's going to be. And we don't have these issues that pop up like that.
Can we look up real quick to see what the minimum amount of visitation that they can produce is? Because that would be the best for us. Every 30 days is the minimum.
That's what I'm asking. Every 30 days. What's your schedule?
It's still too much to have them in our lives that much.
Mr. Hesselmeyer, you're not going to be given a choice. You're in the court system, whether you like it or not. I'm working with you as best I can. You got to cut me some slack. I get it that you don't like it. I can't help that. They're under court jurisdiction. They're under court jurisdiction. This is what's going to happen. Whether I have to do it the easy way or the hard way. If I have to do it the hard way, I'll make you be here. I'll make you come to Gaylord. I'm not trying to do that. I'm not trying to be the bully. I'm not trying to beat you over the head with this kind of stuff. But you've got to work with me or bad things are going to happen.
I have been working with you, Your Honor.
I understand that, and I told you I appreciated that, and I'm doing what I can to work with you. But you can't say I'm not doing it at all. That's just not allowable. If I have to make orders, I will make orders. I'm trying to work with you here, so please continue to work with me. Once every 30 days is something that can be done. I'm giving it to you after hours, so you're not missing work. This is not an onerous request. What time and date do you want them to be there?
Thursdays at 6:30, if that's possible.
The latest possible.
The latest possible that they can physically give me, so that I can have time to even feed my children before they show up.
Like the last 3 times.
The last 3 times we've been cooking dinner while they came in, and it's been quite a headache, Your Honor. And I'm hopping on one foot, spinning in circles, saying, how high do you guys want me to jump here? And they're every time we come in, they're just, oh, he's not working with us right, so that they can manipulate the situation further.
Mr. Hesselmeyer, do I look like the person that can be manipulated easily?
No, sir, and that's why
that's your answer right there. So they don't get to do anything. They're not going to manipulate anything while I'm here. Okay, but I'm also not going to have you tell me what the law requires me to do. So both sides got to give me a little bit here. So Thursdays at 6:30. When does MDHHS want to do its next one? We're looking at either the 30th of this week, the 7th or the 14th of May. When do you want to go?
Your Honor, Thursdays are a night that my kids play t-ball.
Okay. Is there another date that you can do that, Mr. Hesselmeyer? Another day of the week? It's once a month.
What is their latest evening that she can work out with us?
I'm fine with 6 p.m. or 6 to 6:30 p.m. That's fine.
What day of the week is good for you?
Wednesdays would be the best. We could
give me 2 days and I'll have him pick which one's best for him. Wednesday or
you know what, Mondays actually would be best for me.
Monday or Wednesday, which do you want, Mr. Hesselmeyer?
Monday it is.
Monday, 6 o'clock, 6 to 6:30. The date we're going to start is when do you want to start that? You start it in May or you want to start it in April?
Can we start May the 4th? And can we just make it the first Monday of
first Monday of every month? Starting May 4th. Is that all right, Mr. Hesselmeyer?
At 6:30.
And you want it 6 or 6:30?
I would prefer 6, but if they would prefer 6:30, that is fine.
6:30. Is that what you want, Mr. Hesselmeyer? 6 or 6:30? Which one?
At this point, I mean, 6:30 would be the best, but I'll take 6. I'd take whatever I can right now. Just
all right. May 4th, 6 o'clock, every first Monday of every month going forward until the case is resolved. Shouldn't be that much further down. Well, it's going to be 90 days down the road. So you're going to have to do three of these meetings is probably what's going to result in. So
can you ask her if they have paid the gym
I'm
membership?
sorry, go ahead. I didn't hear what you said.
Could you ask if they have paid for the gym membership that they promised my kids? So that they can start going to the gym?
Yes, but she stopped making promises that she's not going to keep.
Hang on. Who's talking in the background? Who am I listening to on your end, Mr. Hesselmeyer?
I'm not sure. What do you mean?
I hear you repeating what they're saying. So somebody's there talking, and they're not on camera, and I don't know who it is. So they're either going to get on camera and talk to me, or they're going to be quiet.
There's the 3 of us here.
As to the gym membership.
Your Honor, the full picture to that is we did get approval to pay for them to go to the Coliseum. We got an approval to do a year membership to do the pro-social stuff that you were talking about at the delinquency hearing. It took them several months to get the account set up that I needed for them to set up. I do need to call and get the gym membership paid for. I have not had an opportunity to do that, but that I found out at the last meeting.
But that's part of the delinquency case and not part of this case, right?
It was just something to try to help them out, yes.
So they're still working on it, Mr. Hesselmeyer. Sounds like she'll work on that as quickly as possible. Hopefully, maybe she'll have some news for you by the time she gets there, May 4th. Don't quote me on that, but I know that she'll work at that. All right. Anything else from DHHS today?
No, thank you, Judge.
Mr. Delaney, anything else?
No, thank you.
All right. Mr. Brown? Don't see Mr. Brown anymore.
Oh, sorry, Judge. No, thank you. Nothing further.
All right, Mr. Dowling, anything from your end?
No, Your Honor.
That'll be the order of the court. Thank you all very much. Appreciate your help, Mr. Hesselmeyer.
Right when I get up to refill my coffee, it figures.
That is how Murphy works.
Larry, at 3:50, you're still drinking coffee?
It's still early. I drink coffee all day.
Very judgmental of you.
I agree with Dave.
Yeah, people don't want me drinking coffee all day. That's.
Excellent. Mr. Bologna.
Good afternoon, Your Honor. Anthony Bologna, Bennett City Judge.
So I'm not gonna make an issue of it. Your motion was filed yesterday. You can respond verbally, Mr. Bologna, okay?
I appreciate that, yeah.
Okay, go ahead.
Thank you. So we received the motion yesterday. And our response would be that.
Well, wait, let him argue first.
All right, go for it.
Go ahead.
Let me go first.
Yeah.
Okay, my motion. All right, thank you, Judge. I think it's self-explanatory, the motion. I believe it's right on point respectfully. We want the court rule says about the interest of justice prior to sentencing, about a motion if the plea itself was not defective by the court or by the attorneys, which we're not challenging. We're saying the interest of justice is the standard by court rule. And that is, it's almost, I wish all my cases were so clear cut, at least in my opinion. And that is, if somebody is a diabetic, and the law and the science is crystal clear that taking a breathalyzer is just not accurate. In fact, the officers are informed on their sheets that if somebody's a diabetic, not to give to get blood. And also the statute, I don't have it right this second, but I could have it in a second. That the only is blood and urine is permitted, obtaining a reading for blood alcohol content when somebody has diabetes. And it's crystal clear my client has diabetes. We have all the medical records for that. I didn't, unless it's sealed, I didn't want to provide those to the court. He can swear to it. His doctor has a letter that says that he's a diabetic. In fact, the letter says that it can cause artificial highs, not negatives, but positives, in taking any type of a breathalyzer reading. And that's why it's blood only. So, Your Honor, I don't fault the officers. Of course, they gave a breathalyzer. But in the interest of justice, this is a very important case for my client, like it would be for anyone. And he's a medical doctor, and licensing to that. And so, it was a 0.09 and a 0.10. And if it was artificially high, what was his real blood alcohol level? 0.02, 0.03, 0.04 maybe, and it's artificially high. So in the interest of justice, and Judge, I've been 40 years, but however long the court's been on the bench, I presume about 30, is that I've never brought a motion like this in this building. And so I truly believe that we have good cause in the interest of justice by the statute or by the court rule, that it would be not fair to set it aside prior to the sentencing and allow him to proceed to trial. In the event the judge was Your Honor was kind enough, for lack of a better word, to set it aside and set a trial, that would be a for sure trial date that will go. I don't expect it to be any more at all than a one-day trial. Thank you.
Mr. Bologna.
Thank you, Your Honor. Yes, I received the motion yesterday afternoon. Thank you for allowing me to respond orally. We were here, Your Honor, as we recall, spent quite a lot of time trying to resolve this matter. We came to what we felt was a good resolution ultimately in this case. The plea was taken. The officer was here on that date. That officer is no longer, that officer is no longer a Trenton officer. So we had a subpoena to get him in here. We were ready to proceed for trial on that date. And we thought we had a resolution reached. As far as the whole argument regarding diabetes, it's a fact issue. I believe the officer, likely being the officer that it was in this case, probably asked if you have any medical conditions prior to against or anything. All that said, Your Honor, will ultimately reach the court's discretion, but the city was prepared to go on a trial or to go to trial on the date that it was actually set. So that's our position on it.
Your Honor, let me just, excuse me, quick reply. And that is, my client was never advised against the attorney. Unfortunately, I don't think practice that area of the law, at least beyond pleas. That is very important and it's instrumental and material in giving a breathalyzer that if you have diabetes, then the acetones, and I put a little bit more of scientific terms in the motion. Thank you, Your Honor.
Anything else, Mr. Blunt?
Better.
Except as provided, this is under 6310B. Withdrawal after acceptance, but before sentencing. Except as provided in subsection 3 after acceptance, but before sentencing. A plea may be withdrawn on the defendant's motion or with the defendant's consent only in the interest of justice. It may not be withdrawn. A withdrawal of the plea would substantially prejudice the prosecutor because of reliance on the plea. I don't know that it would substantially prejudice the prosecutor, but I can't find that this is in the interest of justice. As Mr. Bologna pointed out, there were lengthy discussions that occurred on the date of the trial. There were numerous pre-trials. I remembered when you said sidebar, Mr. Colovis, when you were here for sentencing, that this was based upon the fact that primarily that this was based upon the fact that he was a diabetic.
Correct.
I had read the report, which I never do. I'd read the police report, which I never do before there's a conviction on it. I'd read it the date of the sentence, which I always do when I'm going to sentence somebody. And if you look at the report, it says, Pastor informed me he did not suffer from any injuries other than some back pain. He denied being a diabetic. He stated that he had no recent head injuries. He stated that his highest level of education obtained was a master's degree. He informed me he could understand everything that I was saying. So while your client is now advancing this argument, or you are, I suppose, on behalf of him, the police report clearly indicates that he told them that he was not diabetic. I'm sorry. I'm going to deny your motion.
Your Honor, just if I may, just for the record, just make a record. And Your Honor, he did not say that. And it's on his listing of his medication. And there's a letter from his doctor talking about it.
Well, I don't know how they're supposed to be mind readers.
But even if they,
Listen,
nobody says they are. Nobody says they did anything wrong. I'm just saying.
Says he denied being a diabetic.
That doesn't mean the results.
That means that they might have taken other steps. And this is a decision I'm not gonna reverse myself on. I've thought about this. The interest of justice do not require setting aside the plea. I will be happy to let you appeal this. I will sentence him. You can file your motion to stay any punitive measures pending the appeal. I'll be happy to do that for you.
You don't judge. What if somebody is raped and they're serving 50 years in the DNA comes back? And the person said,
Mr. Clovis, I heard you. I made my decision.
Doing my talking, all right.
Do you want to sentence now? You ready for sentencing?
Your Honor, I would ask this, may we be allowed to do an interlocutory appeal?
No,
immediately?
I'm going to sentence.
You want a sentence?
Yeah, you can take your appeal and you can do, I will stay whatever's punitive.
I appreciate that, Judge. I suppose, go ahead and,
Okay.
with sentencing.
All right. So have you had a chance to review the report with him? And are there any material additions, corrections, or deletions?
If I may have.
Sure.
No? Yeah, go ahead. I understand your prescription.
Listen, Mr. Pastor,
Yes.
you guys can take an appeal. I'm not trying to jam anybody here. You told the police, according to the report, you denied being a diabetic. I don't know what they're supposed to do. Now, even the police officer is lying in a police report, which listen, I'm not going to listen to this anymore. I made my decision. Nobody has ever heard me say I'm always right. Not one person's ever heard me say that. I'm moving on. We're going to sentence. And then you can take your appeal. I have no issue with that.
Thank you, Judge.
All right. Is everything in this report accurate?
Yes, Your Honor.
Any material additions? Okay. Anything you would like to say on his behalf?
Your client, my client is a medical doctor. Medical profession. And he runs several offices with his wife, who's a medical doctor. He denies, and I understand the plea of guilty to appear, but given the other circumstances now that he relied upon, he denies that he was under the influence that day. Thank you, Your Honor. Nothing further.
Sir, anything that you would like to say before I sentence you?
I have been prescribed that for me for the best year and a half. Got all my prescription. Nobody has ever asked me. I do not recall the officer has asked me. I'm not diabetic or not.
Can I see your AA attendance?
Back in the park.
Pardon?
He may have it in the car. Do you want him to go to the car?
Do you have him in the car? Have you been going twice a week?
Yes, I have here. I got it. Can I continue my vehicle?
May he go to his vehicle, Your Honor?
Sure.
3 minutes.
Sure.
Okay, do you want to run out there and go get it? I'll reach back. You'll pass.
I'll tell you what. Come on back up here. Let's just finish the sentence. You give them the probation afterward, okay?
Okay, got it.
All right. Anything else, Mr. Pastor?
No, I'm not sure if any of my medical letters was being presented properly. And that was one of my main concern because of the fasting, my ketone levels and anxiety, and I haven't prescribed 1,000 milligrams of metformin. I got my prescription history for the last 2 years. I just emailed that to Mr. Devolves. I have prescribed for diabetic medications, but I take every single day because my weight went up to almost 200 pounds after the.
I know, but you're not going to argue with me about my decision.
That's not my intention, and I wish this would have came to resolution way sooner. And our previous council would have presented this facts as well too, which I'm just coming aware of it. Is not none of this was being really properly presented, and I'm very disappointed about that because that should have been presented properly in a timely fashion. That was not my intention whatsoever to take this to this far out of context. That was absolutely not my intention. It was not my intention. I asked him to present the facts properly a number of times, and it has not taken place.
I don't know I didn't see anything that your lawyer did wrong. You didn't see anything your lawyer did. Listen to me. I don't want to quarrel with you. You denied that you were a diabetic according to the police report. Now, if somebody tells somebody that they're not a diabetic, I don't know how they can raise the defense that, yes, he really is a diabetic. He was just kidding, and they should have taken different procedures. Now, I don't want to dispute this with you anymore. I've had this feeling the whole time, Mr. Pastor, that you don't think you did anything wrong. You really don't. And you had one 4 years ago. And you're only what? 46? You get one in the next 50 years. That's a felony.
We're not getting one.
Well, I know, but nobody thought you'd probably be back the second time either.
It was not my intention.
Mr. Pastor, let me finish. It's my turn to talk. If you have something else you want to tell me before I sentence you, I will be more than happy to listen, but I'm not going to go back and talk about your lawyer. I don't see what he did wrong. If you have something else you want to say that's going to cause me to be lenient, I'll be glad to listen, but please. Do you want to say anything else?
I'm not here to do anything. He's a such a nice guy.
I don't want to talk about Mr. Zelnick.
Of course. I do not recall the officer asked me if I'm diabetic. I'm taking diabetic medication every single day. I missed it on my medication sheet. I'm taking diabetic medications. I more than precisely every single day I'm taking 1,000 milligrams. It's the highest milligram of metformin you can take. That's for type 2 diabetes. I mean, literally, I was getting heart disease. If I don't take that medication, I said him, show him my
Mr. Pastor.
He's passed that right now, the judge.
And
Not gonna upset the judge.
And you can appeal this. I've never, like I just told your lawyer,
to upset you.
you're not upsetting me, but I'm not going to allow people to argue with me after I've made my decision. You see that guy on the wall right now? Look at that guy. That was my father. You know what he told me when I graduated law school? Don't argue with the judge after they've made their decision. There were 3 things. That was one of them. I didn't then, and I'm not going to let people do it now.
Not my intention, bro.
12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom and poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PVTs, and ETGs bi-week. You're to attend AA and NA twice a week until in treatment. Once you get an outpatient treatment, you no longer have to go to AA or NA. You're also to attend the Victims Impact Panel. 5 days jail credit, 1 served 4. I'll let you serve those as follows. 2 days on the court work program. Those have to be completed by May the 1st. I'm sorry, 2 days court work program. They'll schedule on those, and 2 days of community service by May the 1. Fines $300, costs $300, 75 victims' rights fee, $50 justice assessment. That is 7 1/4. Screening fees $60 for 785. Probation fees are $240 for 1,025. You have cost of recovery of $150 for 1,175 plus $70 in court work program fees, $1,245. You may be eligible for early discharge. If you complete all this in 6 months, you can apply. If you violate, your probation could be revoked. You could be incarcerated for up to 93 days with credit for 1 day served. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer. Now, what I'm going to do, Mr. Kolobus,
Yes.
I'm going to indicate on here, defendant need not report, and will you tell probation this, Amy, need not report. Well, look, I'm prepared if you appeal. You file a motion with me, and I'll make his fines due on May the 10th. But he's going to you can file a motion, and I will stay anything that's punitive. I'll stay which I don't consider to be AA outpatient or victims impact panel. I do consider it to be court work program, community service, or payment of fines.
Okay, thank you, Judge.
So you can file a motion when you appeal, and I'll be more than happy to stay anything that's punitive, but you got to come in front of me and we'll figure everything out. Okay.
Consider it, Judge. Thank you.
And then he's going to go meet still with probation, because I do need him to test. I want him to test bi-weekly. Okay.
Yeah.
And I won't make your money due until May 10th. And when we come back, I presume he's going to file this real soon.
For next week.
I will be happy to extend the time period to pay and to indicate he doesn't have to do court work or community service until after the appeal is exhausted.
That's very kind of you. I appreciate your
Okay.
time today
Thank you.
and patience.
Good luck, Mr. Pastor. Thank you. Regarding the court's denial of defendant's motion to set aside plea based on the claim of ineffective assistance of counsel. Actually, it's not really a reconsideration. I mean, you did mention that in your motion to withdraw the plea, that you felt like there was error by previous counsel, but you really didn't file a motion to ask for to ask the court to find that there was ineffective assistance of counsel. You only filed a motion to withdraw the plea.
Number 4, fourth paragraph of my motion, the defendant files this motion for reconsideration based upon the issue of ineffective assistance of counsel.
Well, I mean, you said it in here, but it wasn't a motion. So I'm just trying to clarify for the record. You never really asked me to find that there was ineffective assistance of counsel before. When you first filed your motion to withdraw the plea, it was based on the fact that the sentencing hadn't occurred as of yet, and the defendant should be permitted to allow them. You can correct me. No. But I thought your initial motion that you filed was to withdraw the plea based on the fact that there had not been sentencing and the plea was not going to, the withdrawal of the plea was not going to prejudice the prosecutor, and defendant is entitled to it under the court rule, at least in the court's discretion. Fair enough?
And in the interest of justice.
Right. And I denied that, but you didn't really, and you did indicate in that motion that you felt, or at least on the record, I remember that you said something to the effect that he wasn't advised by counsel of the fact that the intoxilizer would not provide a accurate result if somebody is diabetic. You did say that on the record, but you really didn't ask me to find that there was ineffective assistance of counsel until this motion was filed. You agree with that, right?
By looking at the first motion, that is correct.
Okay, so what we're gonna do is, you're now asking me to adjourn so you can subpoena the attorney, and
The attorney, Judge, we had a bad conference, and the attorney was confirmed with my client. And last night,
what do you mean the attorney was confirmed with your client?
The Ed Zelenak was to show today. I was hoping it was at 1:00. He sent him and said, I can't make it. I have a trial downtown Detroit in juvenile court in the afternoon. And my client asked, name of the judge. And
Well, had your client talked to him since the last hearing and Mr. Zelnick agreed to appear? Is that what you're telling me?
did you talk to him since the last hearing, or did he just get a show for it?
Or did he just call him yesterday for the first time and ask that he appear? At which point Mr. Zelnick told him that he was not available.
He texted yesterday, that's how they communicate.
Had you talked to him before yesterday since the last hearing?
Yesterday, I spoke with him.
Yeah, but you didn't contact him after the last hearing until yesterday. Is that true or false?
Also, next time, when you have to appear, I immediately.
Wait a minute.
Oh, he said he immediately contacted him when he knew he had to appear.
Wait a minute, Mr. Pest, I want you to listen to my question. After the last hearing, did you call or text Mr. Zelnick in reference to the fact that you needed him to appear as a witness at any point before yesterday? Yes or no?
I did not also know.
Okay, so there was no contact with either one of you with Mr. Zelnick until yesterday, at which point Mr. Zelnick told you he could not appear. Is that true or false?
Correct. Yeah.
Okay. All right.
And my client confirmed, as you put it on the record at the last hearing, that he was contacting Ed Zelenak. They're sort of close, that he'll be here at the hearing. So
I don't remember him saying that.
No, he never said that. You, Your Honor, said that there's going to be, we talked, and I said, Mr. Zelenak, ineffective assistance of counsel, all that. Then you gave us today's date at 1 o'clock.
No, I realize that, but I'm just saying, I didn't tell, the only thing I told either one of you is I wanted the officer to appear, because the defense here is that, as I just outlined, that the defendant is apparently saying he was diabetic, breathalyzer couldn't have been, or intoxilizer could not have been accurate because of that. And there's ineffective assistance of counsel because the defense lawyer didn't pursue that angle. But here now, I told the officer I wanted him to be here because when I read the police report, or I told Mr. Bologna to bring in the officer, because when I read the police report, it clearly stated that the defendant was asked by the arresting officer as to whether or not he was diabetic, and he said no, which to me would mean, if I'm the defense lawyer and I read that, I'm not even talking to my client about a diabetic condition, because the police, but so now we've got the officer here, you got a tape here, and you said initially here, just now at the bench conference, that you're prepared to stipulate to the admission of the video, and that you're prepared to stipulate that it was clear that the arresting officer, and sir, I'd like you to identify yourself, please.
Officer J. Fields.
Asked or inquired of Mr. Pastor if he was diabetic, and it was clear that Mr. Pastor indicated in response thereto that no, he is not a diabetic. Is that true?
That's correct.
So you're stipulating to that.
I'm stipulating exact, yes,
And you're stipulating to the admission of the video.
that's correct.
All right, then let's proceed with the hearing. I'll receive that as Peoples 1. And with that admission, unless you want to call the officer or you want to ask the officer any questions, I'll be happy to let you do that, Mr. Clovis, too. But I'm going to go ahead and admit Peoples number 1, which is the video, with that further provision that the defendant stipulates that that the officer inquired of him as to whether or not he was diabetic, and he clearly stated that he was not at the scene. Okay, fair enough?
Yes, Your Honor.
Yeah. For the record.
Yes.
I have a flash drive that I'll put into evidence, which has the videos on it. Mr. Phillips watch this. And on the video, Officer Fields, it's at approximately 6 minutes, 20 seconds on that video for the admissions video.
Okay.
And I'm stipulating to it.
But I'll receive that into evidence anyway.
Thanks, Your Honor.
Okay, now, so you can call your first witness and we will go from there.
Okay, Your Honor, I have one more.
If you want to go ahead and give an opening statement, I don't have a problem. If you want to do that, if you want to do that, Mr. Bologna, that's fine too. You can both give one or waive your right to give one.
Your Honor, I'm gonna have a tough time pronouncing this name.
Okay.
So I think it's best that I spell it.
Okay.
It's Doctor, and then it's K-H-A-L. Is it A-L or A-T? It's T-I-P. Excuse me, K-H-A-T-I-B-S-H. So you were A-H-I-D-I.
So it's K-H-A-T-I-B-S-H-A-H-I-D.
I-D-I.
I-D-I. I'm sorry. Dr. Katashidi? Is it Dr. Katashidi? Katip Shahidi. I thank you. Katip.
The first name.
Doctor, can you please come up here and be sworn?
Can you ask her first name?
Ma'am, and when you come up here, I'm going to ask you to pronounce it and state your first name for me. Will you do that, please? No, right up to the witness chair here. Good afternoon. Can you raise your right hand? Do you solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth? So help you God.
Yes.
All right, have a seat. What is your first name?
Batul Beta.
I'm sorry?
Batul Beta.
Can you spell that?
B-A-T-U-L dash B as in boy, ITA.
Batul Bita. And then the last name, pronounce again for me, is Khatib Shahidi?
Khatib Shahidi.
Okay, thank you very much. You can proceed.
Okay, thank you. Doctor, first, thank you for coming here today. How do you know, my client?
Collaborating physician.
Collaborating physician?
Collaborating physician.
What does that mean?
I've been with him in the sidelines with monitoring his blood glucose levels because of his family history as well as his own, with diabetes, coronary artery disease, bilateral carotid artery plaque, which is significant for diabetics.
What is your specialty? What type of?
Family medicine.
Okay, so you're a family doctor and you're monitoring his blood glucose levels as well as what?
His blood pressure, heart rate.
Anything else?
His basic labs, regular labs, cholesterol levels, carotid arteries, heart. I've seen him stress test.
How long have you been seeing him? How long has he been a patient of yours?
Well, he's been a patient of Dr. Kazov, family medicine physician, and I was collaboration with her.
How many times have you seen Mr. Pastor?
More than a few, more throughout the years.
Okay, go ahead.
Oh, thank you. What is the difference between pre-diabetes and diabetes?
Well, pre-diabetes is a diagnosis with the A1C at 5.7 to 6.4, and diabetes is 6.4 and up. In the case of diabetics, to consider diabetic, anyone with an A1C above 5.7 with a history of high blood pressure is considered diabetic, even though the range is 5.7 on lab. When you have in the study of high blood pressure history and heart disease and family history, we consider diabetes treated as such to prevent it from getting worse.
Okay,
And he has hyperglycemia as well.
I'm just gonna put this out for a moment. When I get blood testing done, it's like sometimes 8, 9, and he says it should be 7, or closer to 7. What does that mean?
Depending on age and risk factors, below 7 is safe in some people. However, the actual is 6.4 is considered diabetes. 5.7 is considered diabetes when you have history of high blood pressure, family history, and risk factors.
So 5.7 is, I thought you said it was pre-diabetic.
5 on
5.7 to 6.4 is pre-diabetic.
correct, sir. However, when you have a history of high blood pressure, family history, anyone with A1C 5.7 and up is considered diabetic to be treated as such, not meaning insulin, meaning you do the risk factor modification to prevent it from getting worse. Eye doctors, all the eye doctors consider diabetes 5.7 and up. Doesn't matter whether it's pre-diabetes, they call it diabetic.
You have your medical records with you
The medical records of
of Mr. Pastor? Okay. Go ahead.
Thank you, Judge. So, for instance, let's say I'm 8 or 7, and they call me pre-diabetic. Would that be correct?
No.
Okay. Thank you. You already talked about pre-diabetic. Just pre-diabetic, do you know about acetones?
Absolutely.
And please explain what acetone is.
Acetones are what can build up in your blood with significant stress on muscles or with fasting, and build up because your body goes into a state of ketosis, becoming acidotic, to compensate for the blood glucose levels that are higher or low, depending on the exertion level and whether you are fasting or not.
If someone is diabetic or pre-diabetic, would the acetones be higher?
Yes.
Is it a form of ethanol?
Is not a form of ethanol, it's acetone,
Okay.
is a type of, I guess, acid in the body, same as ethanol, but it's different.
Can that be emitted out of your mouth when you talk or blow?
Yes,
Will it, if somebody's pre-diabetic or diabetic, are they usually on medication of some sort?
yes,
What type of medication was my client on?
metformin.
And what is that?
Metformin is for diabetes, 1,000 milligrams once or twice a day.
Okay, did he take any shots?
No,
Okay. And you said he takes prescribed once or twice a day?
metformin, yes, and that is known to cause metabolic acidosis in people who are fasting, which is why we do not give it when you're admitted in hospital, because you're already not eating as much. You're already in fasting mode. So anyone who is on metformin at home is not on metformin when you're in the hospital because you become acidotic. It makes ketones in your urine, in your breath. That's why his CO2 was high in his blood levels too, which is reported in his labs, as well as can be detected as a acetone in the breath. That's how you can tell.
If you're gonna measure by an instrument, measure somebody's blood alcohol content. And somebody blows into it, the tube or whatever, blows into it. Would it be accurate if somebody has these acetones as a pre-diabetic?
No,
Why wouldn't it be?
because you're already acidotic and on metformin and being fasting.
She's not a toxicologist, right?
You're not,
She's not a toxicologist.
but you could testify to, acetones. Do you do that in practice?
Absolutely,
Okay.
absolutely.
And
I just want you to know, I'm not gonna consider that testimony. She's not a qualified toxicologist. So I'm gonna strike that.
all right. But you did state earlier, if I heard you right, that these higher acetones will come out of a person's mouth that is a pre-diabetic or diabetic.
Yes,
And if somebody was measuring that, would it be, how high are they than normal? Is there a way
quantitatively, I have to see on the, what your measurement level is, if it's nanogram per deciliter or milligram per liter, depending on how you measure it in the blood versus breath.
no matter what, they would be higher?
You cannot, that is not appropriate. She is not qualified to testify to that. If you're, no, you're gonna have to get a toxicologist. You should have brought a toxicologist in here then. Ma'am, let me ask you a question. When did you have all your records relating to Mr. Pastor?
Yes.
When is the first time you saw him? And take your time reviewing those records.
2020, 2019.
Okay. And you talked about these levels as to diabetic, pre-diabetic. Tell me what his levels were in you said 2020, correct?
Correct.
What were his levels at that juncture?
Fasting glucose levels were 120 and up, which is considered diabetic. A1C, I don't have the 2020 records of A1C, but their fasting glucose above 120 is considered diabetes when you're fasting.
Did you write I presume you wrote your diagnosis in your records,
Correct. I have the diagnosis in the records.
but any physician, correct me if I'm wrong.
Sure.
They typically go through histories.
Yes.
Conduct tests, and then they come up with a diagnosis, correct?
Correct.
Show me the first time that you diagnosed him in your records with being diabetic. I don't see any reason to not have those marked, right?
Just so it's not a public record, thing, medical records.
Mr. Bologna?
It's a public record. If it's put into evidence, you can just leave it redacted, sensitive information for their at home part of the record. No, I think it should be, if this is the record they want to make it on.
I think they have to be, so.
Well, I regard a part of the record, I just think there's anything sensitive. We haven't seen these.
Well, I think we should have a mark, defense 1. You agree, Mr. Cologne?
Yes, Your Honor.
So let's have them marked and received as defense 1, and I'll be happy to give you an opportunity if you'd like to go back and to redact whatever you'd like. In other words, you can't redact it without.
I'm sorry.
That's a good course.
Okay. Well, can we just, there's 3 items here. Can we just call it all defense, number 1?
Yeah, as long as it's copies of all of her records
These are all the.
that she has maintained with regard to Mr. Pastor.
Which ones were you asking?
I think we should.
The first time?
I think we should have all of her records as it relates to Mr. Pastor marked as defense 1. If you want to take a minute and go through and redact those, or the doctor needs us to make copies, we can make copies, and then we can go from there.
Can we go over them together so I can see which one is appropriate?
I mean, this is all about whether or not he's diabetic.
Correct.
I'm not looking to have his medical history divulged.
Right.
So if it relates, but I think I still need a clean copy. You need your original copy. And then there should probably be a redacted copy that's marked as defense 1.
I would also ask the prosecutor, based upon this evidence, did you stipulate that he's a pre-diabetic?
No.
Why not?
Wait a minute now. It's not your turn to ask questions. Come on. Well, don't be confused. You let the lawyers do the work and I'll do the work. I wouldn't tell you how to be a physician, right? I wouldn't. So don't start questioning why the prosecutor isn't stipulating or why Mr. Colovis isn't stipulating or why anybody's asking you any questions here today. I'll be happy to take the original records, make copies, 2 of them, 1 that will be returned to you, the original, plus 1 that we will have in a redacted form if it's going to suppress information that is not involved. And then, in other words.
Understand, Judge.
And then another copy that's at least a clean copy.
Yeah, these are.
Did you find an area where you said in a diagnosis that he was diabetic, doctor?
Blood work.
I didn't know. Come on. I asked you. I've been going to doctors too. I want a straight answer here. Did you ever write in any of those records, diagnosis, the subject is diabetic?
Yes.
Then I want to see it. Where are they?
Are they here? Are they there? Just pull them out.
Well, it's not in here, not diagnosis, that what blood works.
Here is the diagnosis that you did send me.
Why would you not bring all of your records?
I didn't know why I needed to bring it, so I'm sorry.
Go get them.
You have.
Go get them. This hearing is going on today. And really, go get them. Have them send them to you. They can email them to us. They can fax them to us. I don't need anybody to see anything. But I want to see all your records. Where's your office?
Newport.
Have them send them over. Have them send them over right now. We're taking a recess on these. Would you go get Mr. Holmberg and Mr. Cayley on this other case, please? Recalling Norbert past 25T644-584. Where's the physician at, Mr. Clovis?
She went to Newport to get the records.
I didn't tell her to go to Newport and get the records.
Well, I didn't tell her anything.
What in the world is going on with her? She comes here with parts of her records. Recalling people against Pastor. 25T644-584. Who told her to leave? Did anybody tell her to leave?
I did not tell her.
Well, then why'd she leave? I said, send them. Get on the phone with her, tell them to call and have the office send the records. I'm not waiting for her to go to Newport. She should have come here with all her records. I have a feeling they don't exist. Tell her I said to come back here right now, or else I'm striking every bit of her testimony.
Hey, Judge.
Call her. Mr. Pastor, go out in the hallway and call her.
You know, Your Honor, I did want to reflect on a June 23rd, 22 letter report.
Tell her to come back right now. Nobody said for her to leave.
Okay, well,
I want her back now.
if I may,
No, I'm not going on this case until she comes back. This is ridiculous. I said she could have them mailed here, emailed them here. She only brought part of her records. I want to go back and just ask, do I really look that stupid?
Court calls the cases of the people versus Terrence Smith.
Good afternoon, Your Honor. Raymond Cook for the people.
Joining the public defender, Representative Smith. Mr. Smith, would you state your name for the record?
Terrence Smith Jr. Okay. The motion.
Your Honor, we are asking that the court consider our request as indicated in the bond motion, and a few things we would like to emphasize and information that I received from my fellow counsel. Mr. Brown indicated that he and/or Ms. Pate had spoken to community corrections and were able to confirm that Mr. Smith contacted the community corrections front desk and spoke to them about the about what was happening when he was in the exclusion zone. Yeah. So that's the first thing. And so they were able to confirm that is the information I received. The second.
Well, and I know this wouldn't be you necessarily. Mr. Brown came up at a bench conference, stated that I said I needed something in writing.
So it was my understanding from the notes that the agent said that he was going to submit something to you directly, and I will take a look at that and give you the date that conversation.
Which conversation?
The conversation where the agent told, I do not recall if it was Miss Pate or Mr. Brown, that they would submit something to the court directly.
You received anything from community corrections on this?
So on April 20th, I take it back, it was Miss Virgils spoke with Brian Levitt, who said he'd amend his bond report with updated information, and that he did not contact the client, that is, not contact the bond, or pardon me, the tether agency directly, and the tether company did not contact him, but client called community corrections. And there is a cut and paste of an email to Miss Virgils from Mr. Levitt that says, for clarity, I was misinformed prior to our conversation. Terrence Smith Jr. did not call JSG Monitoring, nor was he contacted by them. He called community corrections and spoke with the front desk officer regarding his violation and stated he was with his cousin helping him move. I will amend my report with that information as well as what else you require.
But I don't have an amended report. I don't have anything.
So I was under the impression that that had been provided to Your Honor based on my conversation. If we could pass for a moment, then I will out my conversation with my colleagues. I will reach out to Ms. Levitt. I will also attempt to get a copy, original copy of the email so that you will have that as opposed to me just reading it from Mr. Levitt.
We email April 20th.
You don't have anything either.
I do not have an updated report. The only report that I have from Mr. Levitt, I received, looks like on April 14th.
So, right, I have is one dated April 14th. But I guess part of the change is particularly the third or fourth paragraph down, that he called community corrections today a violation and spoke to front desk stating he was helping his cousin move, which I don't think was contained in the original.
No, and I don't see that I have that language.
Mr. Neal. That was sent to us on April 20th, or thereabouts. I don't have any timing on that or anything, but I get it. Okay, go ahead.
The second thing that we would like to add orally to our written motion is that Mr. Smith has had time to really think about this and his and what he could have done differently to not have been in this situation. He's taking responsibility. He indicates that he could have and should have gotten more information from his cousin before agreeing to help with the moving, because he did not know it would be in the exclusion zone. He also states that he could have and should have left as opposed to staying area for the 8. Just walked away as opposed to trying to get his cousin to, and what eventually happened, his cousin giving him a ride away from the exclusion zone. The last thing that he's learned, and he said, he and his cousin and his friends and some of his friends have not always been the best influence, and that he has really learned from this that the people that he thought were not for him, his parents, are really the people who have been for him, and that he needs to take their constructive criticism, and because they've been the people who have put money on his books, who have been supporting him with this. So he is asking that the court please consider as part of this that he learned a very harsh lesson, a very harsh manner, but that he has very much so learned this lesson, and that he and that you will not see him in that exclusion zone again.
He's been in since when?
He has been in since April 13th.
All right. Mr. Cook.
Your Honor, I primarily rely on the written response to add just a little bit to that, with that additional report, somewhat corroborate about the defendant helping his cousin move. I think that does give the people a bit more, trying to think of the proper words to use here. I think that helps lessen my concerns as it comes to the victim's safety with that additional information provided from community corrections. Ability still comes from the defendant, but at least shows that he did contact them day of. I think if the defendant were to be released on tether, I understand the victim is not at that original address anymore, I think only confinement might be good to the middle of the round. Just reinstating the bond as it was versus. I would. I'm keeping that.
But prior to this occurring, we had not had any violations. He was on a tether where he could move around.
That is correct.
I believe that's correct.
Okay, fundamentally, the issue for the court was that certain things were said. The other report did not show a call from this defendant to community corrections or anything. Didn't say that he did anything. And I think I brought that up at the last hearing we were at. That I saw nothing that he then did. What it seems that it turned out is that he did do something. He probably should have called JSG, but that's okay. He called community corrections. So that's a big change in this court's mind. But the other thing that's a big change it is that there was nothing that verified why the defendant was in here. One story, but there was at the time of the hearing it was being said, but there was nothing that indicated that he had told anybody that. What's clear to me is that at least contemporaneous with the encroachment into the zone, he then calls, says, "This is what I'm doing." Doesn't seem to me under those circumstances that that's something that's made up. Plus, he's in that zone for what could be a significant period in time, depending on what he's up to. But it wasn't as though he went into that zone and spent half an hour. That's not this case. The problem is and I hate calling people this, but what you did was just stupid. What Mrs. Gaines says is what you should have realized, and that is you go in, it goes off, you get out, you just go. And that means somebody gave you a ride there, that's fine. But if you got to just hoof it out of there, you just get out. Understand?
Yes, Your Honor.
Because see, because of this, you spent what, 17 days in?
18.
Okay. You spent 18 days in and you didn't have to.
Sure.
Right? So you gotta use your head. Right?
Yes, sir.
All right, what I'm gonna do, he had admitted to the violation, and it is a violation. Granted, I'll sentence him to 18 days. Washington County Jail credit 18 served. His previous bond is reinstated with including all of its conditions. And yes, tether, I'm not gonna make it home confinement, I'm gonna make it location track home. I don't know if the home confinement does anything. All right.
Thank you.
And sir, you understand now what you have to do.
Yes, Your Honor.
Right? Yes. All right. Keep the number to JSG and you know the number for community corrections, but get that number for JSG and keep it with you just in case. Okay?
Thank you, Your Honor.
You're welcome.
Thank you, Adam.
Nope. Nope. Stop that. Stop. We're not doing that. We're going back to here. Remember this case, ladies and gentlemen? He just ended a few minutes ago. I imagine you might have a good recollection of what was happening in the case happening right behind me right now. Because Larry, one of our viewers here, pointed out that that wasn't the end of the case. And I was arguing with him because I went back to McNally's site and I looked and I was like, hey, where's the rest of this? And I didn't see it. It was nowhere to be found. So I guess they poofed it. He wasn't on for the rest of the week. Of course, he just didn't stream Friday. And, well, I actually had it in my archive, believe it or not. So I pulled it out of the archives, stuffed it into the cut 'em up machine, and the cut 'em up machine is cutting them up as we speak. It's at 85% right now. I'm not able to give it the nice little vibrant little filter you see behind me. You're gonna get to see what these things look like without the filter. Which, I mean, if you watch Judge McNally every day, like most of us do, you know what it looks like. It's just a little bit washed out. It's not much. But hey, we got a lot more court coming up right now. Don't go anywhere. Don't go anywhere. I am simply vamping while this thing is at 93% right now. 93%. As soon as it hits 100%, you're going to hear it making a little bit of noise. And when it does that, then I'm going to grab the file. I'm going to drag it over to our little playlist that I have popped up over here on the side. And then I'm going to hit play on it, and we're going to see what happened at the end of this hearing.
Officer Field. All right.
Oh, there it is.
I'll
hit cancel on that. I will bring up the folder where it is right now. I will drag it right over here. I will push it right up there like that. And yeah. I'll have to figure out how I'm going to do the music after the fact. But here we go.
Officer Field. All right. While we're waiting for the records, is there anybody else you can call?
Well, I'll call my client, like I say, and I'll have doctor testify. Do you want the doctor first?
No, it doesn't matter to me. I think we should probably have the Mr. Pastor first while we're awaiting this doctor's records, and then we could go to that doctor.
Okay, sir, would you step over here? He's going to take the stand.
All right. Sir, raise your right hand, please. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
So help me God.
Okay, have a seat. You may proceed.
Sir, are you, have you been diagnosed with any medical conditions?
Yes, I have.
And what medical conditions do you suffer from today?
I have pre-diabetes still, and also I have diabetes.
And how long have you had, or at least been told, that you had pre-diabetes from a doctor?
The whole episode has started right after COVID.
Can you give me a years?
It started late 20s, and then it got really bad till 24.
It got bad in 24?
It got bad.
Okay.
It got really bad. It really started after I got the polio shot because.
Well, that's okay. Just answer his question. It started in 19 or 20, and it got bad in 24.
I would say that. Yeah, around 1912, yeah.
Is it regulated? Are you given any medicine for the pre-diabetes or diabetes?
So, yes, so I have been prescribed due to all the different medical conditions. I was prescribed.
Just for diabetes. Let's just talk about your diet. Let's just talk about your diet. Just answer his questions.
Yes.
Have you been prescribed any medication for pre-diabetic condition?
And please speak up.
Yes, I have. So I have been prescribed metformin since late 2019, and I've been on 1,000 milligrams of metformin daily ever since then.
Did you say 1,000 milligrams?
Yes, sir. And I have my prescription records with me of that from my pharmacy.
And okay. And did you suffer from diabetes? I'm sorry.
Did you say you were diagnosed as a diabetic or pre-diabetes?
Well, it is a pre-diabetes, but ideally it is. Some people consider diabetes. Some people consider.
Who told you that you were a pre-diabetic? Who told you?
Couple of doctors.
What doctors?
Pre-diabetic.
What doctors?
One of them was Dr. Hazel.
How do you spell it?
Kasza.
Okay, and where's he out of?
She is out of Riverview.
And when did she tell you were diabetic?
My other primary was Dr. Janeski,
How do you spell Janeski?
Janski.
And where's Dr. Janeski out of?
Out of Riverview as well.
When did Dr. Kaza tell you that you were pre-diabetic?
Officially, it was in 22 when I received my blood work back from.
I didn't listen, just answer my question. I don't need to hear that.
I don't exactly.
Just tell me when Dr. Kaza told you were pre-diabetic. Your answer was 22, correct?
22.
All right. When did Dr. Jansky tell you were pre-diabetic?
Prior to it, because I was already.
Prior to 22?
Yes, because I already had elevated levels of glucose at that time.
I don't need to hear that. I just want you to answer my question.
So yeah, right about the.
Prior to 22?
Yes.
Like how much prior to 22?
About a year, I think, just because I've already started taking metformin about a year prior to that.
So 2021 is about when you started taking the metformin,
Yeah.
and that's when Dr. Jansky told you were pre-diabetic.
Yes.
And then Dr. Kaza told you were pre-diabetic in 22.
22.
Okay, go ahead.
Who prescribed the medicine for you?
So the medicine was being prescribed.
Tell me who prescribed the medicine.
Dr. Tamadi.
Okay.
How do you spell that?
ETEMADI.
ETEMEDI?
MADI.
Where's he out of?
She's out of Riverview.
Riverview. Were all three of these doctors together?
No, different practices.
I
can't collaborate.
I presume on September 1st, 2025, that you were either pre-diabetic or diabetic, am I correct?
Yes, I was doing diagnostics.
Wait a minute. I didn't hear your answer.
I said yes.
Okay.
So you were pre-diabetic in September of 25?
Listen.
Okay, go ahead.
Still on medicine as of today.
Are you still taking medicine for diabetes?
Every night.
And it's 1,000 milligrams still?
Yes, sir.
And is that to balance out your sugar?
Yes, sir. And also control hypoglycemia as well.
Okay, I want you to stick with what the judge says.
Yes.
And I ask you a question, just answer it, no narrative. An example is, what time is it? I'll tell you how it talks to me. Just tell me the time, okay?
Okay.
That's how the judge wants it.
Okay.
The now, did there come a time when you retained Mr. Edward Zelenak?
Yes, sir.
Okay, and did you retain him to represent you concerning this case that we're talking about today?
Yes, sir.
Okay, and did he ever tell you that diabetes, pre-diabetes, will cause acetones and a breathalyzer reading is not accurate? Did he ever tell you that?
Yes, sir.
Objection, Your Honor, calls for your statement.
He has not.
Hang on. She's objecting. Any response?
I mean, I gotta have zone in here. My client's is testifying of the ineffective assistance of counsel.
Any further response, Mr. Bologna?
He's asking for what a third party stated out of court.
You know, I'll rephrase it, Judge.
Okay, go ahead.
I'll withdraw that rephrase it. How many times did you meet with Mr. Zelenak during the representation of this case?
Many times.
How many?
Many.
Many. And was it ever mentioned by you that you were pre-diabetic or diabetic?
It has mentioned.
Listen, hang on. Did you hear his question? First of all, I can't hear you.
Okay, I'm sorry.
Repeat your question and keep your voice up and just answer the question. Go ahead.
Thank you. Listen to the question, and it's a yes or a no. Okay. And did Mr. Zellman, while his representation with you, in meeting with you on this several times, did he ever ask you if you were a diabetic or a pre-diabetic?
Yes, ma'am.
Did you tell him that you were a diabetic?
I told him I was a pre-diabetic, yes.
And when the officer asked you if you were a diabetic, you said no. Why did you say no?
Because I'm a pre-diabetic.
That you're not a diabetic.
Correct. So I didn't want to put inaccurate information. That's why I didn't put that, because a pre-diabetic is not diabetic. So I didn't really know the difference. Now I learned the difference now after all these times, but I did not know the difference whatsoever.
Respect with it. It seems okay. And do you understand now through your treatment, that diabetic is an elevated amount of glucose?
Yes.
And pre-diabetic is still elevated, but not as high. Is that correct? Yes or no?
Yes.
That's all I have, Judge.
Any questions, Mr. Bologna?
Yes, thank you. Mr. How are you?
Good.
Good. I'm good.
Good.
What do you do for a living?
I don't in the office.
You got to keep your voice up, please.
Okay, which medical office do you work?
I work at special care, OBGYN.
You said special care?
Yes, sir.
Where's that located?
Riverview, Michigan.
What do you do at special care OBGYN?
Help with management.
You help with management?
Yes, business management.
What does that mean exactly?
It means business management.
Okay.
Accounts payable, receivable, payroll.
Wait a minute. Wait, listen. I don't have to keep telling you to keep your voice up.
I'm sorry. Yes, work on business management, any and all aspects of business management.
For special care OBGYN?
Correct.
And it's located in Riverview. Do they have other locations?
No, sir.
Are you an owner of that facility?
No, sir.
And you mentioned a Dr. Kaza?
Yes, sir.
And is that your treating physician?
One of my treating physicians, correct.
Okay, and is that a woman?
Yes, sir.
And what type of doctor are they?
Family, internal medicine.
And where is their,
Internal and family medicine.
where's their office?
In Riverview,
Where in Riverview?
on Pennsylvania Road.
Do they work at special care OBGYN?
They do not.
What about Dr. Gansky?
Dr. Gansky.
Jansky.
Jansky? The Jansky?
Janeski.
Janeski. Thank you.
Yes. Who works in Riverview, not a special care.
And what type of doctor is Dr. Janeski?
Internal medicine.
Does he work? Does she? It's a female as well, correct?
Correct.
Does she work with Dr. Kaza?
Correct.
They're at the same office.
Correct.
You see both doctors?
Sometimes. Whatever who's available.
And then there's a Dr. Etamati.
Correct.
Hey, where's Dr. Etamati?
Works at special care.
Okay, that's the facility where you're the business manager?
Yes, sir.
Are you related in any way to any of those doctors?
With Dr. Atamati, yeah, she's my wife.
Okay.
Is there any other doctors in the same office with her, sir?
With,
Dr. Etamati, your
oh,
wife?
yeah. We have other doctors as well, too, yes. We have Dr. Lutzig. We have Dr. Murphy. We have. There's no other physicians there. Those are medical providers.
Okay, so Dr. Lutzik and Dr. Murphy. Okay, that's her.
And you testified you take a medicine called metformin.
Yes.
Thank you. Who prescribed that?
Dr. Tanani,
So your wife prescribed you that script?
that is correct.
And do you know the date of when your wife first wrote you that script?
I do.
What is that date?
I have it on my Rx history from Meyer Pharmacy. I can look it up for you. Right around 2020, 2020.
Is
Right
your,
around that time.
is your wife your primary doctor?
Well, I live with the doctor, so yeah, she's my absolute primary. She oversees me.
But she's an OB-GYN, right?
Well, she's a OBGYN, she's a surgeon, and she's a fully board licensed medical physician as well. She's just a subspecialist as an obstetrician and gynecologist. So she's fully qualified to treat anyone for that matter. And trust me, she does.
Okay.
Okay, that's question is though, is that your
Of course.
primary care physician?
Well, yeah, that too. But I do have my own primary care as well too, which is Dr. James and Dr. Kazan.
Okay, does Dr. Jansky write you any scripts?
Yeah, sometimes yes.
What scripts does Dr. Jansky write you?
She manages also my weight control, mostly the weight control.
Weight control?
Yes, sir.
Okay.
Yes, because of the diabetes and hypertension. Yes. And then if I have any cold or whatever, flu. Usually. So yeah, if Dr. Kazan is available, we'll see her. If neither available, I have my Dr. Tamari will help.
Okay. And there was a doctor that testified earlier today.
Yeah.
I'm going to butcher her name. What is her name again?
Dr. Kuchini.
And do you see that doctor ever?
Only a handful of times I've seen her as a doctor. Since we're just collaborating. Mostly I see Dr. Kaza and Dr. Gineski and constantly Dr. Atmani. But it's plenty of doctors to see, I guess.
How many times have you seen, I know, Dr. Katipsha Hidi? When did you first see Dr. Kashif Hidi?
Around 20, I guess.
What did you go to her for as opposed, let me just ask that. Why did you go to her instead of Dr. Jansky or Janeski
It was,
and Dr. Kaza?
yeah, it was during COVID time. That was just, not everybody was available.
Okay, so you went to her in the first time in 2020 or 19?
Yes.
Okay, go ahead.
Along those lines, Dr. Batul, he testified that 2019, 2020 is when you first saw her as a doctor. Is that,
Yes.
is that accurate?
That's so, yeah.
To your recollection, that's accurate.
Honestly, so.
And is that doctor related to you in any way?
Her?
Yes.
Yeah, she's one of my stepdaughters.
Stepdaughter?
Correct.
Okay, so that would be your wife, Adamadi's daughter?
Yes.
Okay.
Correct. So, because she's a family medicine practitioner, her expertise in family medicine as well too. So she sometimes just becomes as a collaborating physician when my primaries are unavailable, or if I would have questions or Dr. Tamari wouldn't be 100% necessarily able to answer. So, for your understanding, many times physicians do collaborate on cases. In this case, I'm just one of the fortunate ones who has more than multiple physicians who can actually help me.
Can you wait 1 second?
Yes, sir.
So in 2019, approximately, your stepdaughter was collaborating with Dr. Kaza.
Right. We were.
Is that right or not?
Of course.
That's then
Yeah.
just, you said yes, and let him ask the next question.
Yes, sir. We did all the COVID testing together for all the cities.
I don't need to hear that.
I really don't.
You're just supposed to answer the question.
Yes, sir.
Okay, go ahead, Mr. Bologna.
I have nothing further to add.
Did you tell the police that you were not diabetic?
I did not know the difference between diabetics, and yes, I did.
Well, diabetic, if you were told pre-diabetic, you would know that you were either diabetic or just short of diabetic, right?
No, I did not.
You did not?
I just learned all the differences. I really had no idea. I really had no idea. All I knew was that it was out of control completely. I was sick all the time.
That metformin is a weight loss drug, isn't it?
It controls
Is it a weight loss drug in part 2 or not?
It does.
Okay. How much did you weigh?
It helps.
How much did you?
Your blood sugars.
Would you please just answer my question?
Yes.
Is it a weight loss drug?
Yes.
And you've been taking that weight loss drug for about 6 years, correct?
Yes.
How much did you weigh in 2020? So let's call it January of 2020.
So right about.
I just want to know. I don't want to hear all this ad-libbing. Just answer my question. If you don't know, if you don't know, listen. If you don't know the answer, you can say, Judge, I don't know the answer. I'm just asking you a question. In July of 2020, how much did you weigh?
Right about that time, I would say right around 170-ish. And that was the time when
I didn't hear. Just answer my question, sir.
Listen.
Is your testimony that in July of 20 you you weighed about 170 something?
Maybe a little more, but yes. So.
Well, how much is 180, 185? If you know, if you don't know,
I don't exactly know, but there was a time my weight was just skyrocketing, so it was a changing time.
How much weight have you lost since you started taking metformin in 2020?
So at that time, my weight was not really losing.
Sure. I don't. If you want to think to yourself before you tell me the answer, that's fine. I'm just asking you, how much weight have you lost since 2020? This is 2026 right now, right?
Right now, I'm 160 pounds, but between this, I went up to 200 pounds.
Okay.
At some point, when I wasn't taking my metformin, I really went up so much, and it was a beginning of 2040.
You got up to 240?
No, almost to 200, like 196-ish.
And what year was that you got up to almost 200?
23, 24. When?
How long had you stopped taking the metformin before you got up to almost 200?
I was actually still taking it on the spot, and I still went up. So I have to change a lot of diet. Because metformin is not necessarily just for weight loss. Metformin is to regulate the blood sugar levels. Okay.
You started taking it in 2020, right?
Yes. So I really got a lot of weight after when Dr. Janeski started prescribing additional medication, which really cuts the weight down and it's tremendously.
I think these questions call for yes or no. Okay, Mr. Kolobus will have every opportunity to ask you questions then, and then Mr. Bologna can. I just want to get a few things straight in my head. You started taking metformin in 2020. And when you started taking it, you're telling me, correct me if I'm wrong, you weighed almost 180?
Oh, close to it, yes.
Speak into the microphone.
Close to it, I would say.
And then at some point in 2024, you got up to almost 200.
Yes.
True or false?
No, it was horrible.
Okay, I'm just asking. Is that true or false?
True.
And then now how much do you weigh?
Right now, 162 pounds on that one.
All right, so in the last year and a half or so, you've lost 38 pounds, right?
Yes.
Or close to it?
Too much.
She's coming down right now.
Can you explain why you didn't tell Officer Fields that, no, I'm not diabetic, but I'm pre-diabetic?
Well, I said repeatedly I'm fasting. I'm on a 21-hour fast.
I didn't ask you that. Can you tell him why you did not, tell me why you didn't tell him you were pre-diabetic?
I do not know what's there to the diabetic. Well, really, I'm a pre-diabetic. So
You didn't say that, or you did say that?
I don't recall saying or not saying it, but that's the difference. But I did say I'm fasting and I'm on metformin.
Well, that wouldn't mean that a lot of people you would.
Your Honor, I've never been in this situation. I understand.
Yes, you have. You had another drunk driving 4 years ago.
One time. You guys are handling this kind of cases hundreds and hundreds.
Mr. Pastor.
To me, this is very, very new.
Mr. Pastor.
Time I actually had this problem.
No, it's the second time.
Well, that time that was.
You had one 5 years ago. Right?
There was only one time.
Did you, talk into the microphone. Did you or did you not have one?
Only one time happened in my whole life. I never had this kind of problems. I never been as called a diabetic or a pre-diabetic. I know the difference now. I would have just put diabetic, yes, because the effects are the same, but I can still reverse it. I just lost 38 pounds. So I feel like I still can reverse it. That's the most important thing here.
I know, but let's just clarify, because I don't want this record to reveal something different than what really happened. You acknowledge this was your second drunk driving, true?
I had one prior to it.
Object, Your Honor, is to relevance of having a prior drunk.
He just said to me this the first time he went through it. Sir. You had one 5 years ago, roughly thereabouts, right? So this was not the first time you'd been through this situation, correct?
First time I heard anybody ask me about your pre-diabetic or diabetic and this type of form. Yes.
And when you were asked that on this occasion, you unequivocally told the officer no, right?
Yeah, because I'm feeding other diabetic.
And you didn't manage to tell him that you were pre-diabetic.
I would have said.
When did you find out that diabetic versus pre-diabetic or any listen, let me finish the question. When did you find out?
Once we started into this.
Are you going to let me finish?
I'm sorry, I thought you were finished. Sorry.
When did you find out that there was a potential impact on the accuracy of an intoxilizer for somebody who's diabetic?
Throughout this case.
So you knew back earlier, like in the beginning, before you pled?
I mentioned that to.
I didn't ask you that. I asked you the question, when did you find out that the accuracy of an intoxilizer could be called into question if you're diabetic? And you said throughout, correct?
When Mr. Colon was advising me, you should not ban because you're a pre-diabetic.
You did not, but you said throughout the case you understood that. True or false?
Then they told me I had a higher ketones level, and I presented that to Mr. Zelenek, and Zelenek did nothing, and even mentioning that I had elevated ketones level due to my fasting and my pre-diabetes levels. So I was on a 21-hour fast at that time when this happened.
So when you tendered your guilty plea, did you know or not know that an intoxilizer's accuracy could be called into question if you are diabetic or pre-diabetic, as you're trying to argue?
I do not know that. Oh, if I would have known, I would never pled guilty whatsoever. Mr. Zelenek never advised me about this and never advised me properly. Otherwise, I would have never done it.
And you didn't think to tell the officer I'm pre-diabetic? I just
No, I did not think that telling the officer I'm pre-diabetic. He clearly asked that question, are you diabetic? Apparently, don't recollect me. I was nervous, to be honest, but I'm barely going to recollect. I tried to answer everything to my best of my ability, and I actually did have a problem with that because it's a diabetic or pre-diabetic, and I didn't want to make a mistake.
All right. Were you nervous when you answered the rest of the questions that he asked you to, or not?
Of course.
But were there any other statements that you made to the officer that you read in the report or saw in the video that you thought, oh, that's inaccurate, I must have done that because I'm nervous?
I think the sobriety test was something when I thought I did everything perfectly right. But then again, I had chronic back pain from the sports that I done, and he said I didn't do it right, and then following the pain, check it right.
But that's performance of a test. All I'm asking is the officer asked you several questions during the investigative stop, true?
Yes, yes.
And are there any other answers that you would say in retrospect, I should answer that differently because I was nervous and I gave the wrong answer?
I do not recall that. No, I think the officer.
So the only one you think that caused you to maybe be inaccurate with this is the fact that you were nervous because
I would think so. Yeah, I would say so. Yeah.
but none of the other questions.
Well, I was nervous about everything, of course,
But you didn't answer any of the other ones incorrectly, right?
I barely even recall any of the other questions, to be honest. But when they asked me what medications I'm on, I clearly stated I'm on metformin. So I do not know if he knows what's that for, but.
For weight loss.
I'm gonna object to the testimony because it's inaccurate representation of the record. If you watch the video, it was never asked the question.
All right.
Or was Mitchell?
I'm gonna, hang on, Mr. Pastor. I'm gonna stop right here. Do you have any other questions?
Other than just for the record, it's clear, is that you came in to see me at my office, am I correct?
Yes, sir.
That was after you had like.
All right, now wait a second. Now you're kind of leading here, right?
You came in like, well, there's no other way to ask this. After you pled guilty, did you make an appointment to come see me at my office?
Absolutely, yes, I did.
And did you bring your records, including your medical records?
I brought everything what I had available with me at that time.
And also that you had back injuries in the past, correct?
Correct.
And did I ask you if you're a diabetic or a pre-diabetic? Did I ask you
Is that
that?
all of them? One second.
You asked me.
So, Mr. Pastor, wait, is that all the records?
Oh, you know what? This is right there. This is all of them?
Found the email.
Okay, so we're gonna go have 3 copies made. I'm giving the doctor back the original. Actually, have 4 copies made and have them each stapled together.
Okay.
And then one will be marked People's 1 or Defense 1. The original will go back to the doctor. And I'll give you a copy or I'll need a copy. Make 5 copies total. Go ahead.
All right, thank you, Judge. And then did I bring up diabetes or pre-diabetes when I was looking through your records?
Yes, you did right away, sir.
Okay. And did I tell you I also was a pre-diabetic?
Yes, you had mentioned, yes, sir.
Did I tell you at that time what any form of diabetes or pre-diabetes does to the accuracy of an it's a breath machine or instrument that measures alcohol?
Yes, you had.
Was that the first time you heard that?
That was the exact first time when I actually learned it, yes.
And the reports show 0.09, am I correct?
Yes, sir.
VA2. And you've learned since that, does it elevate it or bring it down?
He's not.
Blood sugar.
He's not.
Okay, all right, I'll withdraw that, sir. I don't have anything else, Judge.
I want to ask you one question. You said you told Mr. Zelnick you were pre-diabetic, correct? If you had no idea that diabetes could affect or pre-diabetes could possibly affect the accuracy of an intoxilizer, why would you have found it relevant to tell Mr. Zelnick that you were a pre-diabetic?
So, I get a supporting letter from Dr. Caregiver stating my ketones level will be much elevated due to my fasting routine. That's why I lost all the weight. Came fasting with the medication. It's a collaboration of all that. However, I mentioned that to him, but we didn't really talk about diabetes. We just actually talked about the effect of it. And I mentioned that to Mr. Zagnet a number of times. I was in severe ketosis. The 21-hour ketosis, it's a very high push on ketosis, but that was the only way for me to control my weight and lose all that weight and that short period, well, short, during that period of time.
Okay.
Yes, I did mention that to him. I had elevated ketosis. I give him the letter also from Dr. Berman. Dr. Berman, the psychiatrist. I went to the program, was being advised to go to, and I spoke with her. I clearly stated to her I'm pre-diabetic. As soon as she provided me the documentation, I provided that to Mr. Zelenik right away as well. And that was after.
She didn't have any idea that that had anything.
But yeah.
But the accuracy.
He knows, but I had no idea of that.
It'd be like somebody with gout going to their lawyer and saying, I had a drunk driving and I got gout, right? Am I missing something here? I'm not trying to argue with you. I'm asking.
I'm not trying to argue. I am not trying to argue, but I was keep telling him my ketones level was.
But you didn't think, you didn't know that had anything to do with the accuracy of a breathalyzer at the time, though, correct?
I read about it a little, but I wasn't 100% sure until I talked to Mr. Devolves.
Okay. All right. Anything else?
Yeah, very brief, Your Honor.
Mr. Devolves told me.
Sure. You hadn't, Mr. Kolovas, you hadn't talked to till after the guilty plea, right?
No, he educated me about this.
But not until after the guilty plea, right?
Correct.
Thank you. I'm asking why you told Mr. Zelnick if you didn't have anything to do with if you didn't know it had anything to do with the accuracy.
Yes, this was Mr. Zelnick's job to inform me of it, and he failed to do so.
I see. Okay.
He wasn't in there.
Stop. Let him ask his question.
You testified that Dr. Gaza told you the effects of fasting, correct?
Correct.
And now fasting can create higher ketosis.
Yes,
And
your ketone levels go up. Yeah.
And you testified you were on a 21-hour fast during this period?
Yes,
So
sir.
at what time did you start your fast?
So I start my fast at 10 p.m. at night till 7 p.m. next day.
Okay. You were pulled over at approximately 11:30 in the evening, is that correct?
Correct.
Okay, so did you break your fast of the day with an alcoholic beverage?
That was the first time because this was up, and I'll tell you why. This day, actually, I was in further ketosis.
Answer the question, objection, chief.
At that day, I was in a much more prolonged ketosis.
Well, the question was, you just said break your, was supposed to be a 21-hour fast.
Yes.
With an alcoholic beverage.
I did that.
And that was around what, 10 o'clock?
Something like that.
Okay, so you weren't even in a fast for 12 hours at that point.
No. I was still in a fast since the night before. I haven't had a chance to eat. That day I had to work more. It was a holiday weekend, so I was doing yard work all day long till late afternoon. And the only reason I even went out because I had to buy the Lalo tickets because that was the big jackpot. So I had to learn to do that. That was the only reason. And the only reason I even went to that club because that was the only thing was open at that time over there because it was late. And yes, I broke my fast at that time way too late.
But with an alcoholic drink, did you have any food?
No.
Just a drink?
Yes.
Okay, thank you, nothing further.
All right. You can step down. Thank you very much. Unless you have something else you want to ask them, Mr. Clovis.
No, you're on.
Thank you. You can step down. Doctor, come on up here. We have the records. Come on up here, doctor. Okay. Doctor, I just want to make sure we give these back to the, are these? Wait a minute. ProPath, are these your records?
Dr. Kaz's records.
Where's your records? I wanted you to.
That's what I was given around. That's what they emailed to the girls down.
Okay, these are what was brought to. Wait a minute, I just need to understand this. This is Metro Shores Riverview. Where's your records?
My record, I do not have records. I'm a collaborating physician.
I thought you told me you had records. You didn't tell. You brought records with you, right?
Correct.
Which records are yours? From Special Care OB-GYN?
No, I brought Dr. Kaz's records for review.
Is that from Metro Shores?
Yes.
Dr. Kaz's record?
Yes.
Dr. Kazzer isn't. Okay, wait. Let's do this. There's records here that say Metro Shores?
Yes.
Is that Dr. Kazz's records?
Yes.
Who are ProPath's records? The records here that say ProPac.
Dr. Atamani?
Yeah, okay. I just want to make sure what records you brought. Did you bring the ones from Dr. Kaza that say Metro Shores?
Yes.
All right. Where are the originals of those records? Did you bring them?
I do not have the originals.
Okay, well then, look, here's what I'm gonna do.
All copies, Your Honor.
I know, so. All right, we're gonna have this marked defense 1. And all you guys are gonna be given records here. Copies of those. So on admitting defense 1, that's the records. If there's something you want me to take out, I will. Mr. Bologna, here's your copy.
He's giving, we'll have one, thank you.
So you're just
He's got it.
you're just repeating what Dr. Kaza said. Right?
I have been in collaboration with Dr. Kaza in regards to diabetes.
Well, don't you keep records? You mean to tell me if Mr. Pastor came to your office?
He did not come to my office. He went to Dr. Kaza and Dr. Janeski's office.
Am I wrong? I thought you said you were in Newport and he came to your office 5 years ago, 2020-21.
No, sir. I said I am in collaboration with Dr. Kaza.
Well, you did say collaborating. And I asked you when he first came and saw you. Did I not ask that?
Yes,
And what did you answer?
2019 in regards to diabetes.
Well, where are your records? You don't have medical records?
I was in collaboration with Dr. Kaza.
So he comes to your office.
Not my office. I was with Dr. Kaza in collaboration with her to review.
Where are the records that you wrote in 2019?
I do not have records that I have written in 2019.
How about at any other time? He just testified he saw you 3 times.
Correct, as a collaborating physician to aid with his diabetes and pre-diabetes.
So you met, I want to make sure that I understand this. You are a physician, right? And he at some point came to you, right?
Yes,
In Dr. Kaza's office.
with Dr. Kaza.
And you didn't take any records? You didn't keep any records?
No, sir.
You didn't take a history from Mr.
We
Pastor?
were speaking together.
Why?
Because she and Dr. Janeski is his primary care physician.
All right, I want you to look at defense 1. Where's defense 1 right now? I want you to look at that, as long as you were relying on Dr. Kaza's records. I want you to look at the bottom of page 1. Diagnosis, encounter for general adult medical examination with abnormal findings.
Yes.
Overweight. Dietary counseling. Gastroesophageal reflux disease, unspecified whether esophagitis present. Fatty liver, primary hypertension. Now, these records were from 2022, correct? So June 2022, progress notes by Dr. Janeski.
Yes.
I want you to find one place on any of these records from 2022 or any other record where it says diabetic. Can you do that for me? I'm going to sit here and wait.
On the ProPass lab results, interpretation of his A1C.
What page? What page?
Page is on the ProPath page 1, bottom of the page, 5.7 A1C.
Hang on a second. Hang on a second. I want to stop you now. Blood work will detect cancer, correct? Certain types?
Certain.
If somebody tested in that range, would a doctor not, and the doctors confirm there's cancer, would the doctor not write that as a diagnosis? Or just rely on somebody reading test results to come up with the conclusion that there's some kind of cancer? You understand my question?
I do not understand the question.
Well, look at the diagnosis anywhere on any of these pages and show me where it says listen to me. I'm going to lose my patience real quick if I have it 40 minutes ago. I want somebody to tell me why I'm in here and we're talking about diabetes and I have no piece of paper from any doctor telling me he had diabetes or even pre-diabetes. And he denied it to the police officer. So you're going to find on these records, besides talking about a 5.7 rating, which tells us maybe they're going to be diabetic down the road. And you're going to tell me there's a diagnosis that existed before September 1 of 2025 that showed me that he was diagnosed as a either diabetic or a pre-diabetic.
I know from my understanding from the past, I don't have the exact record in front of me. I was there.
You're his stepdaughter, right?
Yes, sir.
You are the stepdaughter because you are the daughter of his wife.
Yes.
Correct?
Yes.
Find in the record where it says diabetes. You told me it was in there before you told these guys you were going back to Newport.
I did not say I was going back to me. I'm sorry.
Well, somebody told me that on your side of the aisle. It wasn't here. Sadie.
He's down. Wow. You guys want to copy of that?
Judge, there's another medical that I gave that I think you have.
The 5 loose ones.
I don't even know.
And it makes reference.
This is special care. Well, it says increased risk for diabetes, if that's what you're referring to, 5.7 to 6.4, but that's from special care OBG. If there's a diagnosis anywhere that he's diabetic on here, I'd be glad if you point that out to me. Can you do that? Do you have one, Mr.?
Dr. Kazan wrote it here in the letter.
Let me see.
That in the stack, Your Honor?
That happened the first, that was not in the.
So Dr. Kaza yesterday writes that Norbert Pastor was diagnosed with pre-diabetes June 23, 22, right? Even though he didn't have it on his diagnosis sheet.
Yes.
Right? Thank you. That's all I need to know. Anything else? Any questions? Anybody?
No.
Any questions?
Piece of paper you have that I handed, are we gonna have that marked as an exhibit?
You're talking about ProPath?
Yeah.
We can have that marked. Do you want to have it marked and received? Sure.
Judge.
And Judge, we have to stop.
We have to stop. There's something wrong with the recording equipment.
Where'd you go?
And I have
Did you call Shane?
Oh, I think I got it.
You think you got it?
Yeah.
Okay, we're back on record. She's cured the recording malfunction.
This is Dr. Asmahi's lab results in which she indicates as pre-diabetes.
Let me see them. Is that on one of the pages that I have here?
You have it up there, John.
Pre-diabetes.
You gotta shut it.
Okay, and that's from June 3rd, 23 of 22, pre-diabetes.
Where are we at?
This is on the ProPath records, I believe she's referring to. And it's on page 1 of 2 after 5 of 5.
I'm sorry, Judge, what page would it be from the top?
6, I believe.
Thank you.
And it looks like, I mean, I'm not even sure. Is that what that says? He's pointing it up to, 5.7 circle, pre-diabetes. I'm not even sure that's what it says, but nonetheless. I can't. quite make that out. It looks like, honestly, it looks like P6DEBETES.
There are no doctors, right, Judge?
I know they're probably almost as bad as I am. All right, what else? Anything else that you want to tell me? Anything else?
Yeah, I'm just going to place on the record objection to this witness trying to get into the ProCap document as it's looks, from what we could tell, authored by.
I know.
Amati. It was printed on 4/30.
It's certainly not that I understood that she wasn't keeping her own records and she was just testifying about Dr. Janeski's records. That certainly was not the way I took it on direct.
I understand, Your Honor, but for the record.
I understand. I'm going to admit him anyway. Mr. Clovis, anything else that you want to ask the doctor?
No, I'm trying to listen and everybody's spot.
Who's,
Yes,
you don't have any other questions?
I don't know.
Doctor, you can step down. Mr. Clovis, do you have any other witnesses?
Yes.
Just the one.
Is this an actual doctor now?
Yes,
Does she have a diagnosis of diabetes?
yes.
What doctor is she?
You're gonna have to step up there now and be sworn in. I'm tough on these things, Judge. I'm gonna.
I mean, he didn't even testify he went to somebody else. Did he? If this is another collaborating physician that's going to use somebody else's records, I'm going to lose my mind if I have to hear this. What is your name?
That's Marty.
You're his wife, right?
I was the initial ordering.
You're an OB-GYN, right? You really want me to do this? I will if you want.
She ordered it.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got. Have a seat, please.
Your Honor, can I put the general objection on the record?
Yeah,
Just want to note the record because this is such an interesting record at this point.
it's more than interesting.
That this is the spouse who's going to now testify. And so this could be a waiver of the spousal privilege. So I'd like to make that objection on the record and have it noted that this could be considered a waiver of that privilege. So if we decide to proceed.
Okay.
Any response?
That's fine if it'll be treated as a waiver. I mean, there's nothing.
Go ahead. Ask. Go ahead.
And we have a spouse that's gonna be truthful, I think. Ma'am, are you a doctor?
Yes,
Are you a DO or MD?
you.
And what is your specific area that you practice?
OB/GYN
Okay. And how long have you been a doctor?
since 1995.
And have you do you ever check people's patients' blood pressure?
Yes,
Do you ever check their glucose, their
Yes.
sugar level?
yes,
You check their lungs and all those things,
Yes.
right? Okay. And are you aware of your husband suffering any pre-diabetes or diabetes?
yes,
Okay, you'll have to speak up,
yes.
okay? And when did you ever diagnose him as that?
This was going on since we received the COVID vaccine. And after that, because he stopped smoking, he gained weight. And at the same time, we were doing labs. I offered labs, and I did for me, I offered labs for him. And his hemoglobin A1C was elevated.
I'm sorry, what's the last part I couldn't understand?
He was elevated.
Hemoglobin A1C was elevated.
And was it in the area of the results of pre-diabetes or diabetes?
Because I treat gestational diabetes, we consider that diabetes.
I'm sorry, what's that?
Because our job, we treat gestational diabetes. For us, we do not call mildly elevated hemoglobin A1C or elevated A1C, pre-diabetic or diabetic. We call all diabetic.
Okay, so to you or your understanding in the medical field, diabetes and pre-diabetes is the same?
Yes,
So did you ever, that's been telling me pre-diabetes I
it
have,
does not exist.
he's wrong. All right, I'm gonna tell him, all right.
Did you ever tell your husband that?
Yes.
When did you tell him that?
When the sugars were up, hemoglobin A1C.
I know, but when? What year?
About the same time that the ProPAT labs were done.
What year would
Was that 22?
Yes.
What year would that be?
2022.
Okay, and, do you know if he was advised that along with diabetes, you should lose weight, you should exercise, and not eat as much sugar?
Yes, it's indicated in the labs.
And, I'm an Ozempic, but obviously it's not for weight loss. People use these, pills to lose weight, is that correct?
It helps with weight loss, the metformin or glucophage.
Does it also help the glucose and maintain it or bring it down?
Yes.
So it has two benefits.
Yeah.
It's like these shots Ozempic people take that don't have diabetes and lose weight, right? These are different effects it has. Okay. So it's not marketed as strictly a weight loss drug.
No.
And has there been any break in time from the time at first you discussed 2020, 21
Yes.
of diabetes or pre-diabetes? Has there been any break where your husband, the defendant, was free of diabetes, was not taking medication, and he was perfect? Was there ever any time?
We did not repeat labs to prove one way or the other. So once you're diabetic, we consider diabetic. We don't go back and do labs, for example, and say, okay, you're not diabetic then.
You still have blood testing done.
You have blood test and hemoglobin A1C can go up or down.
Okay, but you're a diabetic,
Yes.
correct?
Yes.
Once one, always one.
Yes.
Okay, it's just you try to maintain it, correct?
Yes.
Thank you, I don't have to deal with it.
Any questions, Mr. Bologna?
Yes, thank you, Your Honor. At the time of the arrest, your husband wasn't pregnant, was he?
No,
Okay, you mentioned gestational diabetes, isn't that only applied?
because I treat diabetics.
Right, but gestational diabetes applies to pregnant women, is that correct?
Right.
So that would not apply to men, is that correct?
I was only implying that I do treat diabetes.
Yes.
Whether pregnant or not, if somebody wants help with diabetes, if they don't have access to primary care, I do have.
Correct, but you mentioned that in gestational diabetes, you treat it as diabetic or not.
For the definition of diabetes.
Correct, so your definition of diabetes is based on gestational diabetes.
No. But I do deal with diabetes a lot.
Right, but then there is a category pre-diabetic, correct?
I am not sure. I hear that's an argument. They do call sometimes pre-diabetic versus diabetic. So
Okay, but you don't know for certain.
for certain,
You said you're not sure, so that would imply.
well,
that
I
you
do
know
know
for
what
certain.
you mean. For a lot of doctors, pre-diabetic is the same as diabetic.
And you also stated that you agree with the statement of once a diabetic, always a diabetic. That's not true though, is it?
You do have the inclination to become diabetic, yes.
Correct, but there's certain types of diabetes that with health and diet, you eventually will be considered not diabetic, correct?
I don't think so.
You sure about that?
Yes. I don't do that. I don't say you're diabetic.
Do you know for certain that you could eventually be classified as diabetic and then based on diet and how?
I believe physicians, when they call a person diabetic, it's all of the diet.
You're not an expert in diabetes.
Maybe not, yes.
And do you prescribe any other medications besides metropin?
I do not for insulin.
What about with your husband? Do you prescribe anything else?
No.
Just that's the only pill you write
Yes.
for him? Okay, and you said though you do prescribe insulin,
For patients, yes.
but not for your husband.
No.
You just said it to do metropin versus insulin?
I mean, they're different. They're oral hypoglycemics, that's metformin. And then we have the injectable ones. If the type 2 diabetic doesn't improve, they become type 1 diabetic. And you can get insulin as well as, or you can be on both at the same time.
All right. Anything else? Sure.
Thanks. Well, you stated earlier that once a diabetic, always a diabetic, is
Yeah.
that correct?
To my knowledge, yes.
Yes or no?
Yes.
Okay. And, you can try to maintain the diabetes of an individual by taking medication, correct?
Yes.
Okay, and doing exercise, correct?
Yes.
And losing weight, correct?
Yes.
And, don't take in so many sugars, into your system, correct?
Correct.
And somebody that isn't a pre-diabetic or diabetic, telling that if they eat a lot of sugar, they don't become diabetic right away. I mean, it may in the future, but not right then, right?
Correct.
Okay. Now, cancer, somebody can have cancer and it goes into remission.
You're kind of lead.
Well,
I mean, I'm giving you leeway, but I don't know how much more of this I can do.
just a couple of questions.
Go ahead.
Can cancer go into remission?
Objection, Your Honor. How's this relevant to anything?
Because I'm going to do an analogy.
Go
This
ahead.
isn't a jury.
Yeah, cancer can go into remission.
Okay, and doctor, can cancer go into remission? Yes or no?
Yes.
Okay, and if it goes into remission, do you still have cancer? You consider it?
No.
You don't have cancer if it is in remission?
It is in remission.
Okay. And has this diabetes ever gone into remission with your husband?
It can be controlled, but we don't say diabetes is gone.
Okay, thank you, no.
Any other questions, Mr. Bologna?
No, Your Honor.
You can step down. I'm sorry, I'm gonna go ahead with closing arguments. This isn't really, I'll listen to whatever you have to say. I'm not gonna adjourn this so the lawyer can be subpoenaed. I'll listen to whatever you have to argue, Mr. Clovis.
Okay, Your
I
Honor.
mean, I did read the briefs.
Okay. We rely on our briefs, the motion for reconsideration or rehearing, given the ineffective assistance of counsel. Because my client said no to diabetes, if he had that. He wasn't asked pre-diabetes, and I understand what the court is saying. But that doesn't all of a sudden negate the test results. It doesn't all of a sudden say, oh, okay, those test results are good because he didn't tell the officer that he's got diabetes or pre-diabetes. No, that's where there's justice that needs to be set aside because those aren't accurate. It was a 0.09. And he felt with the plea that it's an 09. What it turns out to be an 03 or an 04. And he pled guilty to something that he's not guilty of. So in the interest of justice, we're asking just that it be set aside and that it be scheduled for trial or pre-trial.
Thank you, Mr. Clovis. Mr. Bologna, anything?
Yes, Your Honor. Today is the date to have set for a hearing. What I still don't know today is how, if someone is diabetic or not diabetic, that actually affects the PBT or affects the data master or affects the Toxilizer 9000. I don't know. And that was the purpose of today. What we do know is that the defendant had testimony from 3 doctors, both which he's related to, claiming that he's potentially pre-diabetic. There's been documents put forth to the court that indicate there's a glucose level that may be pre-diabetic, but there's nowhere in any report from any doctor, or testimony from any doctor that he's actually diabetic. That said, we still don't know if that even affects the results here, but we still don't even know how he has an effective assistance of counsel, because what we know for certain is from the video that was put forth as evidence, Your Honor, where he states unequivocally in the video, when asked the question, are you diabetic? No. For those reasons, Your Honor, I don't believe they've come anywhere close to the burden of establishing ineffective assistance.
Anything else? Sure.
The last doctor testified that we find is a diabetic.
Well, let me tell you something. But for the reasons he just mentioned, I don't see how this possibly rises to the level of ineffective assistance of counsel. I just don't. I mean, you got somebody here, his wife, Mr. Pastor's wife just took a, Mr. Pastor, I want you to let me finish before you start talking to your lawyer. His wife just testified that she advised him the pre-diabetic was the same thing as a diabetic in 2022. Yet, in September of 2025, he told the officer he clearly was not a diabetic. I have no evidence as to how much the toxilizer can be affected, the accuracy of it, though it might be. But how does somebody go tell an officer I'm not a diabetic and then expect to have their conviction overturned or their plea allowed to be withdrawn because they later try to argue that they are a diabetic? And in fact, his wife just testified, like I said, that back in 2022, she said it was the same. And I don't have any evidence that he was a diabetic. The only thing I have here is a medical record that says increased risk for diabetes, 5.7 to 6.4. That doesn't mean he's a diabetic. So I don't know what the argument here is, except Mr. Pastor apparently regrets his plea. I'm sorry about that. And now I've listened to his stepdaughter come in here and tell me there was a diagnosis. There's no diagnosis. There is no diagnosis on any of this that says diabetic, pre-diabetic, even patient-advised risk for diabetic. All it says is 5.7. That's it. I mean, I go get a physical every year and they tell me what the numbers mean, but nobody here, no way do I see anything as a diabetic. And I don't know why a lawyer would even inquire whether his client's a diabetic or not if he just read a report that says, I am not diabetic. And now Mr. Pastor comes in here and tries to tell me, well, I'm a pre-diabetic and I didn't think to say that. And I knew about it before. Then he says he didn't know about it till he talked to Mr. Clovis. But then he said, I knew about it throughout, and throughout include a lot more with Mr. Zelnick representing the defendant than Mr. Clovis, because the case went on forever. This is, like I said, at least the 8th time they've been in court, I believe, at least 7th, maybe 9th. I don't know. But I just don't believe any of this testimony. I don't believe it from the wife. I don't believe it from the daughter-in-law. I don't know why she would have told me she had a diagnosis and she had her records, and then it turns out they're Dr. Jansky's records. This is not a game we're playing in here. Defendant's motion to withdraw the plea or for reconsideration is denied. Now, I told you when you filed your motion before that I will certainly, but you're going to have to file a motion. I'm not trying to create work for you.
I understand. It's a simple motion.
It's a simple motion that's going to set forth that you have to diligently prosecute the case. I will stay punitive matters. I will not stay things like treatment or testing, but file a motion. I'm going to accommodate you. If you want to have it in 2 weeks, Mr. Clovis, I'll be happy to accommodate you. I haven't done that in 10 or 15 years where I had to enter one of those orders, but I'll be happy to do that for you.
I appreciate you doing that, Judge, with regard to a stay, as to the other matters. My client's been doing everything else.
Good.
And actually stated that at our last hearing.
Right. So I'll be happy to, I want all these records put in something that is marked confidential. Will you do that for me, Heather? Put all these other records in a folder that says confidential. So I'm gonna ask you to try to file your motion next week, if you would.
Yeah, I'm gonna try to.
And I'll have it the week after when they're here. Okay?
All right, thank you.
Thank you very much.
You have a very nice.
Mr. Bologna, are you my docket in 2 weeks or 3 weeks?
It would be.
He is here next on the 7th and the 21st.
So if you want to do it the 21st, I don't have a problem. Just make sure you perfect your appeal, okay?
Yeah.
And I'd like you to submit an order to me, Mr. Bologna, denying the motion so I can sign it. Will you do that for me, please?
To clarify for the record too, there was the motion to recount, but then this was also set for a Ginther hearing. Is that also denied as well?
That's the Ginther hearing, and any motion for reconsideration of the motion to withdraw the plea is also denied.
Judge, on the 21st, I'm downtown in Frank Murphy Hall.
I will accommodate you if you want to do this by Zoom.
Okay.
Just have your client with you, okay?
All right, very good.
Thank you both.
All right, gentlemen.
Oh, I don't want this.
Okay, let's get going on this other one. Lisinski.
And to
we gotta have our song.
Well, you know the number for community corrections.
all the
Get that number for JSG and keep it with and keep it with you just in case. Okay.
Thank you, Your Honor.
You're welcome.
Thank you, Adam.
Judge Simpson. Always thank you, Judge Simpson. And it's always appropriate. Ladies and gentlemen, to end with a good Judge Simpson hello and goodbye. I have a lot of things to say about the McNally case. I just don't even know where to start. I don't even feel like I'm qualified to even say half the things I think in my brain. So I think I might just bow out. Bow wow wow wow. Because I don't know anything about the medical realities of diabetes, OWI tests, and all that type of stuff. But I do know when I feel something suspicious is going on, I can say that I think something suspicious is going on. And ladies and gentlemen, there's everything suspicious about absolutely every stage of that hearing. I don't even know where to start. We're watching Judge Boyd tonight, ladies and gentlemen. It is a crazy long, it's about a 2-hour long one, I think, unless I'm mistaken. I do have a little bit of editing I still have to do on it. But just a warning for Marty out there. I know he doesn't like Judge Boyd. But this is a good Judge Boyd. And we're not going to get many more because she's not going to be back in the next go around. She was voted out in her primary. So we're gonna check this one out because I thought it was fairly interesting what happened. It's a motion to revoke. Pretty positive. That's it. It's a contested hearing. That's the proper terminology. Well, before this gets too far into all these things, let me click the little magic button over here and say a very hearty thank you very much to Nina out of the blue, Kiernoth, and Steven! Thank you very much, you shenanigizer. Granny, great to see you. Mama, always great to see you. Barry, Felix, I can't even read everybody's name fast enough because I'm just silly. My name's on there a lot. Well, I don't even know if there's a way to keep that from happening, but oh well. I do like my stuff. I will, if you want a candid admission from a creator today, just know, ladies and gentlemen, I do actually like my own videos. I hope you like and subscribe and do all the fun stuff too. And by the way, speaking of liking and subscribing, little old Wolfbot has his own channel and he likes to stream after show parties when we go off the live stream over here. He's live right now with some more McNally from sometime in February, I believe. If you're interested in more court, it's here for you. We're redirecting over to Wolfbot. I'm 90% sure I actually have the URL right here, ladies and gentlemen. That's what it looks like. That's what a URL looks like, in case you're wondering. That right there. Thank you so very much for hanging out with me. I'm your Lone Wolf Oosla. We do these things every single night of the week, 8 p.m., 9 p.m. Central. We're going to be together again tonight with a premiere at 9 p.m. Central. No, Eastern. Oh, God, I can't even remember my own time. There's a schedule thing here. It pops up every so often. Go hang out with Wolfbot. I'll see y'all later. It's been great. Chat, you're wonderful. Thank you so very much. I'll talk to you next time. Bye.
Officer Field. All right. While we're waiting for the records.
See, that happened. Well, while we're here, though, watch this. This is natural. This is without a filter.
It's something we'd like to say on his behalf.
This is with a filter. Doesn't he look so much more orange like that? I mean, hey, and the wood looks wood. It's less muddy. All right, so keep this vibrant colorful palette in your mind. Oh, I could have done better favors right there. And then this is what it looks like otherwise.
Field.
See the difference? Kind of crazy, isn't it? You can kind of see right there, he's got the red in his cheeks, but the filter just really brings it out. Get out of here. I got nothing else. Go on. Wolfie awaits. Thank you all. Goodbye.